Hello, everybody. Hello, hello,
Hello.
hello. Happy Monday.
It
Are you
is
having a good
Monday.
Monday? Because
I
I'm having a very good Monday and a good
It's
hair
been a
day.
good Monday. A hot Monday, but good.
Oh, really? Oh, it's nice
It's
here, but
hot.
I've been in the air all day,
Yeah.
so.
I'm staying inside. We have the Ring of Fire this week, which is apparently something over our area, and we're going to be in the hundreds. I think it's like 4 or 5 days in a row.
Oh, you mean for like wildfires and stuff?
Yeah. I'm like, what is
Oh,
it means like we're going to not have a lot of humidity. It's going to be very dry, but it's going to be very hot.
mm, wow. I
So,
hope that's not
no
too big of a
rain.
problem. No rain. That's that's not
No
great.
rain.
Well,
So,
hello, everybody.
yes.
Welcome to the new True Crime and Wine Time live show.
Yes.
That very excited about today because I know I've been wanting to talk about Murdaugh for a really long time. A lot of people have wanted uh, me too, us too, and I think it needs a lot of attention because I find that there's a lot of like, what? Why did he get a new trial? This doesn't make any sense, and I get where that comes from,
Mhm.
but I think we need to maybe learn and watch the appeal hearing to see what happens. And then I know that we
Agreed.
want to, keep up with
We
the
wanna
Murdoch
keep up.
coverage because the new trial has already been underway. Well, hearing wise, not they're not in the
Right.
trial right now, but the whole process has started all over again. And I do think it's going to be very different uh, than it was the first time around.
I
So
suspect it will.
I hope,
And I'm excited, and I know a lot of people have different views on it, but I'm curious to see this time and what they
yes.
do different.
Hello, Lady in Gray. Good afternoon. Amber, hello. Good afternoon to you. Finally catching a live in the background while I work. Well, good.
Good.
I'm glad we can keep you entertained while you're working.
And we'll
Hello,
try
Belle.
to say anything that makes you laugh out loud. Too bad. Hi, Belle.
Hello, Bells. Oh, you like the countdown? Well, we didn't have a new video yet for this show, so countdown it is till we get something fancy going. Um, but so let's just talk a little bit about Murdaugh before we get into the appeal hearing. So why don't you give them the basis of in
Yeah.
case somebody never watched the first trial or,
Doesn't know.
doesn't know.
So, in case you're new to this, Alex Murdaugh was a respected attorney from what they were calling a legal dynasty,
Mhm.
that they said was untouchable. Okay.
And and in the courthouse are literally
There are
pictures,
pictures of them.
oil paintings of
So when
this
we say they were influential legal family,
yeah.
it's true. But Alex's it started cracking, okay? Because of financial crimes, deception, but I think most importantly, a double murder.
Yes.
Yeah. So, and in 2023, which I can't believe it's been that long. I
Yeah.
feel like it was just like last year, but Alex Murdaugh was found guilty of the murder of his wife, Maggie, and their youngest son, Paul. Okay. Now, he was sentenced to 2 consecutive life sentences without the possibility of parole. Okay. Plus,
Mhm.
that was on top of what he had already been given for his financial crimes,
Which were a whole lot of those.
which was a whole lot. So, yeah, his fall from grace, and I think the whole family's fall from grace has been a dramatic thing.
Yeah. For that era, yes. I mean, listen, I have a lot of unpopular opinions, as always,
As well.
regarding Murdaugh and the whole thing. Personally, I find listen, he wasn't the only corrupt person around there. They
Mm-mm,
weren't. There is corruption rampant everywhere.
everywhere.
Um, and I know for me with the first trial, so like I went in being like, yeah, this dude
Mhm.
definitely guilty, right?
I did too.
And then I watched the trial each day, because I like to watch trials for funsies, uh, as do many people
Mhm.
who subscribe and watch us. Which, if you haven't yet, like, subscribe, hit the notification bell so
Yes.
you don't miss when we go live to talk about Murdaugh. Hi, Bella's mom. Hello. Good afternoon to you. Hope you're doing well. Um, and as I was watching the first trial go on, the state did not, to me, fulfill my need of burden of proof. If I was on that jury, I would have my vote would have been for not guilty. Now, that is the beauty of juries, right? It
Mm-hmm.
is 12 different people putting all of their experience, everything in there. And that's just my take. That doesn't really mean like anything because we're not the jury. But had I have been on, to
Mm-hmm.
me, the state story didn't make a lot of sense to me. And I did have some reasonable doubt in certain areas. Now, listen, we can all agree that Alec is a scumbag, all right? Because he
That we
is a
all agree on.
scumbag. I do not like that guy. I think he is trash, all right? But the state didn't do a few things that I needed to get there. I understand there's the video of him there. Yes. There's lots of other things that they brought up that gave me some reasonable doubt. For example, the doing $20,000 worth of prescription opiates a month. That doesn't make sense. Their
Doesn't.
motive that it was the financials didn't really make too much sense for me. But and there was some data which I do think is very very important to the trial. But if there's anything we've learned from the Karen Reed trial is that it can be questionable at best.
Mm-hmm.
Um, and so what and I'm going into the second trial again, new open mind, new open
Okay.
mind. It's a new trial. The state again, the burden is on them, and it doesn't really matter how I feel about Alec. So we'll see. You know what they do this second time around. But as soon as that trial was over, I had been saying for 3 years he was going to get a new trial because I
Oh,
didn't think it was a fair trial at all, and that's why. Uh, that's like the biggest thing that I know a lot of people get frustrated at. Um, is this? Well, he did it, so why do we need to go over this again? But
we still need
again,
to
if there's
have a legal and fair trial.
a legal and fair trial because we've watched other trials together on this channel and before where the state just railroads people
Mm-hmm.
whether you think again whether you even think the person did or didn't do it, it is up to the state to prove to you that they
Mm-hmm.
did. And now maybe the state proved that for a lot of other people. I mean, we all have different
Levels of.
levels, and there's nothing wrong with that. That's why we have the jury system. um, and I'm fine with my opinion being unpopular about it. But I am interested to see how we take from jury trial, uh, the first one, and move it into this retrial and see what the state did differently, does, if anything, does differently. Just like I'm going to compare it to Karen Reed a lot. That's not to say that I think Alec is factually innocent because I
Right.
can't claim that either. Um, but I am curious to see what the differences are. I have
Mm-hmm.
heard that I believe it's the defense has already hired some defense experts from Karen Reed's trial,
I've heard that.
particularly about phone data, infotainment, all of that. So I'm very interested to hear that testimony from both sides.
From
A
both
lot is
sides.
a lot has been able to be worked on over the years. And so I'm very, very interested in this. Your first non-low live. Well, welcome, Bill. Happy to have you.
It's still just
Um,
as crazy.
Still just as crazy. The Murdaughs are crazy. I mean, it's a wild, wild story. But so we decided before we go in to watch the first hearing of the new retrial, we decided, you know what we're going to do is we're going to cover the appellate hearing that granted him a new trial. Because most people have never watched an appeals court before.
I haven't.
You haven't. I find them fascinating because they are very, very different than the other courts. They focus more on rights as opposed to anything else, really. That's their job. They're not there to argue all of this other stuff that was done in court. And they work a lot differently. So if you've never seen one, you may not be as nerdy as I am, but there's some of my favorite things to watch. Hopefully I'm not hyping it up too much.
I was to say, you're hyping it up, girl. But I like reading the transcripts of appeal trials. So I've done that. I've just not watched one. So, but I am curious to watch it.
It's curious to watch the judges in these. It's a panel of them. It's curious to watch the lawyers in them because it's a different kind of lawyering. They got to be quick because they're getting, questions right out the gate all the time. Anyway, so we thought that this was a good place to start to see what the arguments were that led to this new trial anyway. Now, we all know Becky Hill has something to do with it. I call that right out the gate. This is why you don't want to do anything that can grant a new trial. So anyway, it's about 2.5 hours long. I don't think we're going to get through it all today, but we've decided that for now, Mondays, we're going to dedicate to Murdaugh Mondays because not only does he have this retrial, he also has a civil lawsuit against Becky Hill, which is also very interesting. And we want to cover both of these as they're happening in real time. So we're a little behind, but we're going to catch everybody up as quickly as we can to be on top of it. So let's go ahead. And what else do we need to do next? Sorry, I lost my whole outline here.
I don't know.
Okay. Well, do we want to just get into the hearing?
Let's just jump into it.
All right. So the hearing is brought to you today by the Trial Channel, one of my favorite channels. She does an amazing job over there. I've been watching her stuff for quite a long time. She goes through all of the hearings and everything and takes out all the dead time, like all the breaks, everything like that, and just puts it all back together, which is really, really nice.
I was to say that is really nice because we both know that's a lot of work.
It is a lot of work, and she's been doing it for quite some time now. So if you don't, and it's no commentary over there, she just brings it all, together, takes out all the parts to save you time. So if you haven't yet, go subscribe to her over at the Trial Channel. She also has the Trial Files, which is one of her newer channels. I think over there she has the Karen Reed, the interrogation tapes of like the Alberts and all of them. I think that's over on that one. But lots going on.
That one out.
Yeah, they're both really, really good, which we'll be discussing Karen Reed on Couch Court with Llama this week too. Very excited about it. So I look forward to, or Lady Grace says, I look forward to seeing what the defense does with the Kennel video. Yeah, I mean, I know with the Karen Reed, many of the people I know that watched the first trial still went in the second trial open-minded, but we all saw how that went. Hi, Nicola. Hi, lurking and cleaning. Happy to have you.
I mean, I have an unpopular opinion. I'm not saying he's innocent, but I don't think he pulled the trigger.
Yeah. I mean, we'll see.
They didn't prove to me that he did.
Yeah, we'll see.
We'll see
what they bring around this time. I don't think he got a fair trial. One, they should have brought a jury from somewhere else or moved it first and foremost.
They should.
But you know what? They're going to explain to us why
we're going to
both
learn.
sides. And I haven't seen these guys in so long. Poot and Jim over here. Those are, if you can see my mouse, this is Alex's side. Over here is the state. Oh, that, wait, is Crichton there? Oh, maybe that is him. I can't really tell. But Jim over here is an appellate attorney. So while he was part of Alex's defense team for the trial, his specialty is appeals, and they had him on the team for a reason. But anyway, let's get into this and see what they say.
I'm excited.
Yes,
so grab your snacks.
We are going to do commentary. We're going to pause all of that stuff. So if you don't want to hear any of that, as I said, just go to the Trial Channel, watch her video, give her a sub and a like. But let's see what they got today.
Good morning. Please be seated.
Oh, real real quick, by the way, I just want to say this happened on February 11th of this year. Just so we're in the right timeline here, okay? So February 11th of this year was when this hearing took place.
The case for oral argument this morning, State versus Murdaugh. I believe the clerk of court, Ms. Howard, has already instructed to turn off your cell phones. If you have not, please do so. The courts in South Carolina are open, and we appreciate those who are present and here to observe, not participate. For those present who are not arguing in this case, please do not disrupt the proceedings. Any outburst or disruption will result in sanctions for contempt of court.
Mm-hmm. Another thing, this is not Murdaugh related, but Richard Allen from the Delphi case, like his is being brought up to the Supreme Court of Indiana at the end of September. And I'm thinking about going because I know Nick Starro, Defense Diaries, they're all going there. And Nick and I were talking about it. So I might go just to also witness this process in like real time. Because this is what, if you're following that case, this is what's going to be happening on, I think, September 21st. I don't know. I'll be talking about Richard Allen probably as we get closer.
Now you're going to stuff in person. Wow. Llama has come a long way.
Oh, no. Why did my camera decide to be?
Your camera went away.
Going to do this again today? StreamYard?
It's a Monday.
It is a Monday.
It is a
There
Monday.
we go. It says, no, thank you. That's fine. We'll work it out. It's fine. Let's see. There we go. Oh, you know what? It's going to make me do?
What?
It is going to make me restart my computer, probably. We'll see if it does it one more time. It's fine.
We'll see.
We'll see. It didn't. Oh, yep. No, it is. Hey, real quick, why don't you, sorry, everybody, technical difficulties. This happened when I was on Nick's like 2 weeks ago, and I have to restart my whole computer and everything. It won't take very long.
Okay.
But why don't you just entertain them and send them some promos or something? Okay? I'll be right back.
Sounds good. So while Llama is off fixing the technical difficulties, let's see what all we got going on. So tonight we have our members only appreciation stream. I forget what time exactly that is happening. I think it's 6 p.m. Eastern. Then I know at 9 p.m. Eastern, I'm back with Dearest Mother's Darkest Secrets. And I am going to tell y'all tonight's case is hard. And I'm going to just be honest and say, I do not understand the depravity of some people. It's a case that's going to make you say, because it makes absolutely no sense. Now, if you're new here, Couch Court with Llama, which is one of TCWT Media's shows, it now has its own channel. Now, for a little bit going forward, we are going to stream all Couch Court with Llama content on both channels, but here in the near future, it'll be just on Couch Court with Llama. So what does that mean? You all need to go over to Couch Court with Llama, subscribe, hit that notification bell so you know when she goes live. She's currently been covering the Laura Owens case. And I'm going to try not to be funny, but I am. So, and she's covering the cute little minifigs over there. And like she said, she's going to start doing Karen Reed. She's got a lot of stuff going over there. So if you like to watch trials, that is the place to do it. Now we are going to cover Murdaugh here, but go over there to see all of Couch Court with Llama and her sidekick Buffy, who is there a good bit of the time. Okay. Now, if you are a new member or if you are gifted a membership, definitely come to our member appreciation thing tonight. We spin a wheel because Llama loves spinning wheels. Okay. Almost as much as she does trials, if not more. And we are going to be giving away some really fun stuff tonight. So you definitely want to come and check that out with us. Now, I don't know about you guys, but I'm excited. I've never watched an appeal before. I didn't know they ever did them live. I've just read the transcripts of them. So I am excited to visually see it. Llama and I are kind of close on this. I don't think he got a fair trial. Okay. So whether he's guilty or innocent, to me, it doesn't matter if you don't get a legal and fair trial, because you can't say someone's innocent or guilty if you don't have a fair and legal trial. So I'm very excited to see, because I've been good and I haven't looked up on why all he won the appeal and why he's getting a new trial, because I knew we were going to be doing this. Now, Bells, you said he's old. Are we talking Murdaugh is old, or was that when the judge was up there? And what constitutes old? Because according to my grandchildren, I'm older than dirt. So whoever's old, are they older than dirt? Are they? Oh, poot. Okay. I was like, who are you talking about? Okay. So yes, I'm older than dirt. So he must be older than dinosaurs, right?
I think I'm back.
Okay, she's back.
Hopefully. It didn't give me any things. This was trial and
Uh-oh. Good thing we can't hear the words she's saying right now, because I have a feeling they're probably some not so great words. Uh-oh. So she left again. Okay. She left again. Yeah, technical difficulties on a Monday is always exciting and fabulous, right, guys? So be sure, if you haven't yet, like this video while we're waiting on Llama to get stuff worked out.
all right.
Hit the notification bell, but hit it for all, not just this show, because then you won't get notified on the other ones. I just had to go in there, hit the dots, unnotify, and then hit redo it and hit notify all, so that you can get notified. And while we're waiting on
Okay.
Mama, it's also a good time to go and hit the subscribe button for Couch Court with Llama. It's a good time to do that too.
Yes, please do.
Please do. We can hear her.
Yes, we can hear her. Hold on, I'm going to go out. I just reset my camera. Maybe that's it. Go out,
So
come back
Lady in
in.
Gray says, I don't think a fair trial issue with regards to jurisdiction is part of his appeal, but you're not 100% positive about that. Well, that's not my only reason for thinking it wasn't a fair trial. I have thoughts, which we know I have thoughts. Okay. Uh-oh, she's coming back in
Okay.
to see. There she is.
If it keeps going, whatever. We're just going to keep watching it.
Okay.
We don't have time to sit here and mess with camera stuff today. I'll tell you what.
Yeah, I've gotten to do that every time we go live. I restart my computer every time before we go live, just to be
both
sure.
Nick and I were having problems that day. All right. Anyway, let's get back into
Let's
this,
do
shall we?
it.
Let me turn on these closed captions. Go.
Make this
Good morning.
bigger.
Please be seated.
I forgot to check and make sure I'm under the right account, so we don't get that. No, I wasn't. See?
See?
Resets all my things. Okay. All is well in the world.
All is well.
There we go. All right. Let's do it, friends.
Good morning. Please be seated. The case for oral argument this morning, State versus Murdaugh.
Oops, sorry.
I believe the clerk of court, Ms. Howard, has already instructed to turn off your cell phones. If you have not, please do so. The courts in South Carolina are open, and we appreciate those who are present and here to observe, not participate. For those present who are not arguing in this case, please do not disrupt the proceedings. Any outburst or disruption will result in sanctions for contempt of court. As we proceed with the argument, just want to notify counsel that on the primary argument, as you begin your 20-minute allotment, 5 minutes will be given without court interruption. So you'll have 5 minutes before we jump in with questions.
It's gonna be tough, Chief.
And we'll have to show some restraint to do that. At the end of the first issue on the post-trial motion for a new trial based on alleged misconduct of the clerk of court, and before we get to the underlying trial evidentiary challenges in that matter, we will take a short break. And I believe, Mr. Harpootlian, you're going to handle the first issue.
Yes, Your Honor.
Oh,
We're ready
Poot.
to proceed.
Please record, Your Honor.
Yes, sir. Good morning.
Listen, I know people have their opinions about Poot, but like he does have a flair for the dramatic. Like, and when I think of a good old Southern country
think say
lawyer, like he says,
He is
He's
a
something.
good old Southern
he's
attorney.
something. I remember being so frustrated with him during the trial. Like, Poot, what are we doing? Anyway,
Morning,
sorry.
and as I understand your instructions, I get 5 minutes without being interrupted.
Guys,
Yes,
Wow.
5 minutes.
Well, first of all, I want to thank the court for, I know what has been a very diligent effort to wade through this record, a 6-week trial, and then a post-trial hearing that went a few days with additional, 2 hearings, I think, with additional record. So this is not a
Something.
simple matter. But before I get to that, I want to just remark on this.
It's been
As
so
I
long.
came into this courtroom this morning, I'm reminded that half a century ago, I sat right about there as Chief Justice Woodrow Lewis had us stand and hold our hands up to be sworn in as new members of the bar. All of us could fit in this room. That's how long ago that was. But one of the things that impressed me that day was the oath. And part of that oath was that we swore to uphold the Constitution. And as I stand here today, I'm honored to be arguing about how to interpret that Constitution, the Sixth Amendment specifically. And in my opinion, I would suggest the Sixth Amendment may be the most important amendment because the First Amendment, which gives you the right to speak without government interference, or the Second Amendment, which gives you the right to carry a weapon or have a weapon without government interference, mean nothing without the right to a fair trial and a fair jury. So this matter we're discussing this morning, a fair trial, a jury not poisoned by outside influences, I would submit to you is 51 years ago, as I stood there, I did not realize what I was swearing to do, but I do today. And that is to defend Alex Murdaugh's right to a fair trial.
Mm.
And I've got to admit, in the 51 years since then, I've never seen a factual pattern like this, where the clerk of court sets out to influence the verdict, to get a guilty verdict for financial gain.
Mm. Mhm.
Now, I do want to go to the record fairly quickly and summarize it so that there's no misunderstandings. Rhonda McElveen, who's the Barnwell clerk of court, was asked by Becky Hill, the Colleton clerk of court, to assist her during the Murdaugh trial. She testified under oath that she was told by Ms. Hill that she, being Ms. Hill, might write a book because she needed a lake house. A guilty verdict would sell more books. That was said before December of 22. We didn't pick a jury until January of
that's
23.
not good.
No, it's
The
not.
best way to sell books was a guilty verdict. A guilty verdict would be better for the sale of books. So she explained she had a financial incentive for a guilty verdict. She also made comments to her like, don't be fooled by the evidence presented by Mr. Murdaugh's lawyer. Watch him closely. Just before he testifies, look at his actions, look at his movements. Identical to the statements that I'm going to read you in just a moment by the jurors as they were questioned. Juror P, on the day Mr. Murdaugh was taking the stand, Becky Hill made a comment, watch his body language. Juror X, prior to Mr. Murdaugh's testimony, Juror X heard Becky Hill say words to the effect of, looks like the defendant's going to testify. This is an important day. This is an epic day. It's rare for a defendant to testify. Jurors.
This is unbelievably inappropriate. Unbelievably inappropriate.
It is. It's, yeah. I'm trying to think of the word.
Inappropriate.
No, there's got to be a
inappropriate.
stronger word. Like when a basketball player throws a game because he bet on the game.
Yeah.
You know,
I mean,
it's absolutely wrong.
And it's important to think too that I don't know this to be true. I have not read all the Becky Hill civil, docs yet. But whenever you see something like this, you have to wonder, has it happened before?
Right.
Because she knows better. She knows.
Oh, she knows better.
Very much knows better about this. So then you have to be like, okay, well, when else have you done this, Becky? There shouldn't be any conversation with any of the jurors about anything.
When you go back and look at all the court cases that she's been involved with.
Exactly. Right.
Savage. I like that. That's some bullshit.
Exactly, Bells.
Yeah. What? Yeah.
Z, watch his actions, watch him closely. In addition to that, Juror Z said in an affidavit and affirmed in court that Ms. Hill told her not to be fooled by the evidence presented by Mr. Murdaugh's lawyers, attorneys, which she understood to mean Mr. Murdaugh would lie when he testified. And that Ms. Hill instructed the jury to watch him, Murdaugh, closely immediately before he testified, including look at his actions, look at his movements, which Juror Z understood to mean he was guilty. Alternate Juror 741. Before the defense put up their case, Ms. Hill told the jurors the defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Hill told Jury 741 Murdaugh was going to testify before he testified. That's what the jurors said under oath. That's what the clerk of court of Barnwell County said under oath. Judge Toll from the bench said at the conclusion of the hearing, asked the question, did clerk of court Hill make comments to any juror which expressed her opinion as to what the verdict would be? Ms. Hill denies doing so, and so the question becomes, her denial credible? Was her denial credible? I find the clerk of court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed it as early as November 22, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McElveen, and others her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified. She made some of those comments before he testified to at least one and maybe more jurors. The clerk of court allowed public attention of the moment to overcome her duty.
Can we consider the egg juror's affidavit?
I'd like you to.
The egg juror.
In the record, of course, you mentioned during the hearing, she's across the street. Judge Toll said, no, she's not going to testify. She let the alternate juror testify for impeachment of Ms. Hill. That's what her stated reason for was during the hearing. What was the rationale for her not allowing the egg juror to testify?
I don't know. Because as you point out, if juror 741 was to impeach Becky Hill's credibility, now she, of course, she was not a deliberating juror.
Well, neither was the alternate.
Correct.
Who did testify.
Correct.
So my question is this, and I'm sure Mr. Waters will cover this. If the egg juror's testimony was just as theoretically impeaching as juror 70 or the alternate juror's testimony 741, why wasn't the egg juror allowed to testify?
And I'm not sure that she stated a coherent reason otherwise, other than she wasn't going to. Remember now.
But she said her affidavit is in the record, so we know what she said, Ms. Hill said,
Right.
and we now know what Ms. Hill said she didn't say.
Yeah.
The egg juror, I
So
know, right?
I
Hold on.
take that to mean that it was considered. The egg juror's affidavit was considered by.
So I don't know if they're going to explain who the egg juror is or why egg juror is so important. So egg juror, they call her that because she brought in fresh eggs for everybody every day, which there's nothing that's juries are allowed to do all that has nothing, but that's why they call her that, is because she would bring in eggs,
Well,
if I recall.
I don't think it's appropriate, just so you know. I think
Well,
it's mean.
I think it's, but anyway, I'm pretty sure she was the one who the court got wind of her ex on Facebook claiming that she was at a bar talking about all of this. Now, if, and correct me if I'm wrong, chat, if that's not who the egg juror is, but I'm pretty sure it is. And, or she asked if she could take the eggs home. You're right. She asked, they dismissed her. Anyway, I digress. Has to do with eggs. Well, it doesn't
Okay.
have to do with eggs. All right. So they get this win that her ex is claiming on Facebook that egg juror is telling him stuff. Well, it turns out they don't even have a relationship. If I remember right, I believe there was some sort of like restraining order between them. Like it sounded very, very, very weird. And so they ended up dismissing her completely from the jury over it, even though all there was to go off of it. And she was brought to talk in front of Judge Newman. I don't believe we heard that, but it's been like 3 years, guys. So my memory's a little, but I do know that she was brought to talk. She said she had nothing to do with it. She doesn't even talk to him, and they let her go. So that's who the egg juror is, if I recall. Is that
So-
right, Chet?
Buffy asked when I served, it was a civil case, but we were told we couldn't bring stuff for other jurors or buy things for them because when it came down to voting, that could influence the vote. Somebody might want to side with you because you brought them something
Could be.
like a quid pro quo.
Yeah. I mean, I think I could say it's an argument. It doesn't apply to this. Nobody cares about the eggs. It's more about the Facebook post.
Eggs were hard to find back then, and weren't they really expensive?
In 2023?
Yeah,
I don't know.
I don't remember. But
Maybe it
there
was
a time
another
eggs
juror
were
that brought them
expensive.
in, and she asked if she could take them with her. I don't remember, but that's the story of this juror, if I recall correctly.
David
Chicken
bring
wings.
chicken wings, Skittle for all.
I love that. All right. So, and this judge is asking, well, wait a second.
Why?
How come one juror was allowed to testify about this, but egg juror was not allowed to, even though she wrote it? That's what this judge is questioning. Like, because they did question all the jurors, not with judge. This is well after the trial. They brought them all in, made them all go under oath, and this is how they have all this information. And so this Supreme Court justice is asking, like, well, why one was allowed to, but not the other one?
Why did you
What's
pick
that
and
about?
choose?
Yeah. Well, I think it was the judge that picked and choose, but I'm not entirely sure.
By the court, and we can consider it.
In our defense, when you look at the record, remember, we were starting off with no one was going to examine anyone under Judge Toll's initial order. And then it was a moving target. Then it was going to be some that were going to be examined. We weren't going to be allowed to examine. Then we
Okay.
were allowed to examine. So it was an evolving process. If she in fact considered the egg lady's affidavit, she did not cite it in her order. Just as she did not cite Juror Z or 741's statements about do not be fooled, comments about how the attorneys are going to try
The
to
state
deceive you.
argues in its brief that Judge Toll, in making specific finding as to certain things jurors did say, was an implicit rejection of the other statements the jurors said Ms. Hill made. What's your response to that?
Well, I would say that's wholly unsupported by the record. I mean, a judge in an order is going to say what they considered and they should say what they didn't consider and why. This implicitly, I mean, the statements by 741, by Juror Z and by the egg lady, all had bearing on Cork Hill's credibility, and what happened is critical. And let me say this also, even if you didn't have what they said, if a judge, as the jury came in on the day Mr. Murdaugh was going to testify, said, it's an important day, it's an epic day, you better watch how he testifies, and doesn't say that about any other witness, except some sort of charge at the end of the case, or maybe before, but specifically points that out.
Mr. Arbutlian, let me ask you this.
You guys, I
Judge
love you. I
Toll
miss you.
placed the burden on your client to prove prejudice in this case. Does Green establish, in a case with external influence on a jury, a different standard and burden of proof than Rimmer and the Fourth Circuit jurisprudence?
No, it does not. It's consistent with Rimmer. All Green says is, we're not going to go through this burden shifting or any of this until we determine whether the statement was inconsequential. I say inconsequential or consequential. And if it is inconsequential, we're not going to go through this analysis. That's all it said. And I'd point out in Green, the process used by Judge Toll of calling all the witnesses up and asking them if it had any influence. Judge Hill, in a footnote in the Court of Appeals Green decision, points out that 606B, he says it's not raised in this case, but should we be asking jurors anything about verdicts? And that's another complicating factor with the process that Judge Toll used. So
that's an interesting point, because Rule 606B says that you can't consider the effect of something on jurors, because otherwise you're invading the thought processes of the jury. But how could the state rebut the presumption without doing that?
Well, I mean, I think very simply, all the other cases that you look at, if you look at like Parker versus Gladden, where a deputy says he's an evil fellow and, he's guilty.
Right.
They say, you can't rebut that. That's not rebuttable. And so he gets a new trial.
But in Parker versus Gladden, they talked about the prejudice.
Well, it's the prejudice is apparent. If you use the standard some of these cases use, which is the hypothetical juror, would it objectively influence the hypothetical juror? I mean, I think that's what the state has to do, is say these comments would not affect the hypothetical juror.
But in your brief, you also
he's already been granted a retrial, Dave. This is the appellate hearing with the South Carolina Supreme Court. And then they've already done their first hearing for his new trial. This was granted. And the judge that he's talking to right now is the one that wrote that footnote in the case he was just referencing.
Which I thought was kind of cool.
Mm-hmm. I'll say this, being in front of a appeal Supreme Court, from what I've heard of other lawyers that have done that, is a very nerve-wracking experience, because you have to be like he has no idea what any of them are going to ask, to say, and so you have to know things in and out. A lot of the lawyers that argue for the United States Supreme Court always have very interesting things to say about their experiences with it. So you didn't know how else you could use scrambled. Oh my God, I didn't even see it there.
As Exodus say, he was just trying to get another an egg joke in, because he's got egg yolks.
Oh, you guys are so funny.
say that the presumption ought to be irrebuttable. Are you standing by that here today? Or are you wanting us to follow Rimmer and Parker and say it is rebuttable, but you have to use the objective standard on an average juror in considering the effect?
Turned over easy.
Well, it is, I would concede that it should be rebuttable, but in a situation like Parker versus Gladden, I don't know how you rebut it. I mean, it may just be, it's rebuttable, but there may not be any way to rebut it.
In some circumstances, the conduct can be so reprehensible and egregious, it becomes a de facto structural error.
Mhm.
Well, I read your opinion, Rivera, Court of Appeals, on structural error, where the judge refused to let the defendant testify in a death penalty case. And I've digested,
Oh,
or as my wife would say, digested, not digested, I'm sorry, that case and the structural error analysis. And I must say, Mr. Griffin and Mr. Barber and I have had a significant discussion on whether that would be structural error as opposed to not letting a defendant testify in a death penalty case. It could be, but I don't think we need to go there for this opinion, for this case. I think the clerk of court tells everybody that'll listen, I need a guilty verdict. She tells everybody, so I can make money. She tells everybody, so I can buy a lake house. And then she proceeds to talk to jurors, not about inconsequential things, but focus on how to view the defendant's testimony, and to juror Z and to juror 741 into the egg lady. Don't believe him. Don't believe his lawyers. I mean, I submit, more than enough
egregious.
to meet the Parker
That's-
versus Gladden standard, or the Cameron standard, or I think it's Bennett, the case we looked at. I just looked at yesterday. All of those are cases in which there's no question what was said wasn't inconsequential, wasn't neutral. It was an effect of influence.
Is it a finding of fact or a conclusion of law by Judge Toll, where she wrote on page 31 of the record, this court further finds that the improper comments made by Clerk Hill were limited in subject and not overt as to opinion? I know you say that language was put in there by the state in its proposed order. I don't want to talk about that because
Okay,
she
debatable.
signed the order. But is her finding that the statements were limited in subject and not overt as to an opinion a conclusion of fact or law?
That's a conclusion of fact, which gives rise to a conclusion of law. But that statement is wholly unsupported by the record. I would submit an abuse of discretion.
Mm-hmm.
And how about her finding that those comments were cured by Judge Newman's overall jury instruction that the verdict was to be based on the evidence presented and the law as he gave it, and not on anything else?
Well, then you would never have, as long as the judge gave the appropriate charge at the end of the case, you'd never have a case of jury tampering. You could have somebody bribing a juror, and according to her reasoning,
It's a good argument.
I took the money, but I'm not going to do what I said I'd do. I don't believe for a minute that is an appropriate analysis of the law. Whether I believe it or not is really irrelevant.
So the allocation of the burden of proof is not dispositive in your judgment. Even if it was erroneously assigned to you, you believe you met that burden of establishing prejudice because of the nature and frequency, the pervasiveness of these comments by the clerk.
If you use the analysis in both the Court of Appeals decision of Green and then the Supreme Court decision in Green, if you look at the analysis, that's exactly what it is. There's not going to be any burden shifting or anything if it's innocuous, but if it is something other than that, then the burden does shift to the state. And we've met our burden. There's no second. She had a two-prong test. Second prong was, did it affect the verdict? Well, I mean, if somebody that can't work for Rule 606B for one, but more importantly, you're asking jurors to unpack for you what influenced their verdict. How did they get there? Which you can't do under 606B, and people can't do, period. I mean, if somebody had walked in there with a gun and threatened everybody, and then left, and the jurors were polled a year later saying, no, I thought the evidence was overwhelming. It didn't matter whether somebody walked in with a gun or not. And overwhelming evidence is not the standard. This Sixth Amendment, I was going to go somewhere historical. I'm not going to do that. But
I'm not going to.
yeah, I am.
You got 3 minutes.
The
Yeah,
Sixth
yeah.
Amendment
Yeah.
was based
Quit to it.
on, as you know, English common law
Mhm.
in the trial of Aaron Burr in 1807
Oh,
for
okay.
treason. This is not for killing Hamilton. This is for trying to sell part of the United States to Mexico. He was a piece of work.
Sure was.
Chief Justice Marshall quoted from Lord Coke, or Coke, who said, "A juror must be as indifferent as he stands unsworn. His verdict must be based upon the evidence developed at the trial. This is true regardless of the heinousness of the crime charged, the apparent guilt of the offender, and the station in life which he occupies." You can't say it any clearer. And that's what the Sixth Amendment guarantees. And that didn't happen in this case.
We understand that everyone, regardless of the heinousness of the offense, the character of the accused, or the apparent guilt of the accused, in no manner diminishes the right to a fair trial. In your effort to set up that this is a man for all seasons moment, we understand the gravity of the situation and the entitlement of every individual to a fair and impartial trial.
Your Honor, I never doubted that for a moment. I think I was saying that more from me than you, because it's such a great quote. And again, came up during Aaron Burr's trial. He was such a terrible person. But even he was entitled to a fair jury. We quote
It's
in
strong
our
opinion.
brief, and I want to expand on it just a little bit. If you look at United States versus Elbaz, which is a Fourth Circuit case written by our own Jay Richardson, he details what Remmer requires, to trigger the presumption, the defendant must introduce competent evidence of extrajudicial juror contacts that are more than innocuous intervention. And I submit we've done that in this case. But the presumption's rebuttable. The government defeats the presumption by establishing there exists no reasonable possibility that the jury's verdict was influenced by an improper communication, which was not done in this case. You should exclude, at least one, I would point out, Juror Z said it did. I mean, if we're going to go that way, now,
go
it
there.
may have been ambivalent. Judge Toll says, I said in the record, it can be both pressure from the jurors and what Clerk Hill said. But I don't think we need to go there, because 606B and almost all the cases about external influence don't allow you to ask the jurors questions about how they got where they got.
A part of Parker versus Gladden was that the Sixth Amendment was violated because the bailiff there, who said this person's guilty, this wicked fellow, whatever, became a witness in the case. Is that what you're saying Clerk Hill became in this case?
Well, not necessarily. What I'm saying, Parker versus Gladden, they only needed 10 or 12 to get a conviction. And the Oregon Supreme Court said, well, we had 10 that weren't influenced by whatever the bailiff said. The Supreme Court said very clearly, doesn't matter. You're entitled to 12 impartial jurors. Also, that was the case in which the United States Supreme Court adopted through the 14th Amendment, the Sixth Amendment to the states. So that's the reason I like Parker, because it's got so many different levels that are very helpful in this case.
And in Parker, did it took 10 to convict in Oregon, right?
Yes, sir.
How about Judge Toll's finding that even if the state had the burden, she found any possible presumption of prejudice was overcome by the facts and the court's findings. She did conditionally rule that if I'm wrong about the burden, then the state has overcome that burden. Well, the presumption, excuse me.
Two things. One, she doesn't detail what that overwhelming evidence is. And we're going to hear from Mr. Griffin in just a moment as to how underwhelming that evidence is. Number one. Number two, that can't, the level, if the level of evidence dictates whether or not you get a fair jury, then again, we go back to what Judge Marshall said, no matter how heinous, no matter how overwhelming the evidence, you're still entitled to a fair trial. I mean, if only the people that may be innocent get a fair trial, then our Constitution isn't working. I don't care I would submit this court shouldn't care. No one should care when there's a Sixth Amendment violation like Becky Hill committed in this case. And let me say this, I know my time's up. We spent months getting ready for this trial, weeks, 6 weeks trying this trial,
Mhm.
more months finding jurors to talk to and find out if the court could talk to her, could talk to them. We had more hearings, more briefing. Nobody wants to do this again less than we do. But that's not the issue. It's not how much trouble it's going to be. It's what is Alex Murdaugh guaranteed to under the Sixth Amendment.
Thank you, sir.
Thank you, sir.
All right, so I'm going to pause it here just real quick because this one, Teri, how do you feel about watching appeals in the Supreme Court as somebody who's never seen them before?
I have to say that it's interesting, and I just wonder how much case law he had to research in case things got asked.
Yeah, that is something that
Because I
many
mean,
prepare.
like, he has to know them word for word. And I like it, and I like that there's not the interruptions going back and forth
Yeah,
about this, not sustained,
yeah.
overturn. I mean, I like that it just goes.
Now, it's important too. So what they were just talking about, in case somebody joined in late or something like that, what they're arguing at this point was Becky Hill's involvement of speaking to the jurors, right? Because the way juries come to a decision is something that no one likes to interfere with. As a matter of
Mhm.
fact, it's a big no-no to do, even after the fact. And what they were arguing with the different case laws was that it's kind of already been ruled in different ways,
Right.
right? Like, so the problem with Becky and what they're arguing here is she stated stuff about how people should pay attention and feel. The jurors would never be instructed to such a thing in court ever, right? They even tell you in court instructions, you get away at each and every person's testimony, expert, non-expert,
Mhm.
doesn't matter. They don't tell you who to pay attention more. Becky is also in a position of power and influence,
Mhm.
right? She is somebody who works at the court. She is somebody who sees this every day. So
And she knows more things.
yes, for her to insinuate in any way, pay attention to this, this, and this is grossly inappropriate. And this is why little comments can be turned into big ones that upset a whole case. It's very, very important that people don't interfere in these sorts of things. And so that's what they're arguing here because while the judge that heard all of these jurors is saying, yeah, but what Becky did wasn't enough to influence them. But jurors have said that it did,
I was gonna say, yeah,
some. And even if it's one, that's enough.
one's too many.
And also, it could, when you're getting pressure from the local community, it's just like the same reason they tell you not to go watch the news or stay
Right.
off social media is because they don't want other people's opinions
To
to influence you. And that's exactly what Becky Hill did. She was a
She-
walking, talking Facebook post every
And-
day.
And why she even spoke to them. I mean, yeah.
Yeah, it's not great. So that's what they're saying because normally they wouldn't. What the judges are asking is, does this qualify as something egregious enough that whatever the jury's decision at the end of the day doesn't really matter because you can't really sit there and say, at what level did Becky's comment egregiously affect things? It's very hard even for them to say that themselves as a juror, but some have. So,
But I also think any vision of impropriety should be taken that way because you don't know. You can't 100% know. But the fact that one juror said it did.
well, think about this. Like when you're watching a show, right? You're watching it with somebody who's already watched it. You've never seen it. And they're one of those people that's like, oh, wait for this, wait for this. You're going to like this. Pay attention to this thing. What happens?
Oh.
You do that thing that they tell you to do because they've
Mhm.
told you, they've hinted that there's something there important.
Right.
And that's what is being implied here that
Mhm.
Becky and her behavior has implied these jurors To
And-
maybe not.
And her being
Well.
in the position she's in, if I was a juror, I would be like, oh, she must know something that we can't know.
Right, because
Or what
many
did she see that they didn't let in? Oh, I should listen to her. I mean, if
if
you've never been on a jury before, you're gonna think,
if you've
oh,
never
okay,
been
I
a
need to
jury,
listen.
you've
Yeah.
never been in a court situation before, it's very, very, very powerful. And here's Exhibit A, why here we are
Yeah.
because of that. But anyway, I just, in case somebody came later, I just wanted to fill them in on what Poot has been here
By the way,
arguing
your
with.
red hair is flaming today.
Oh, is it? Oh, thanks. Thanks. It's much brighter when I straighten my hair. All right, so let's continue on. I'm gonna go.
Good morning, Ms. Waters. Good to see you, sir.
Good morning, Chief Justice
Oh.
Kittredge, and may it please the court. I'll start out with my 5 minutes, and I'll start by saying I also agree that oaths are important. That's something I always talk about with juries and the importance of their oath. And I think that that's also recognized very strongly in this court's case law and case law of other jurisdictions. And that this court has expressed that jurors are presumed to take that oath very seriously, that they're presumed to be people of ordinary firmness, that they are not presumed to blow with the winds of every opinion that swirls around them. And so I think that's an important place to start when we look at this particular case. And when we look at this particular case, what we are talking about is what Justice Toll described as a few fleeting comments. And in the face of that, we have to consider a 6-week trial with almost 90 witnesses, with almost 600 exhibits, with Judge Newman, with the entire prosecution team, with the entire defense team, and all of that presentation over 6 weeks. And to get there and to do what ultimately is the analysis is we have to assume that at some point prior to deliberation, during the presentation of evidence, with all of that going on, some jurors like, well, I didn't know what I was going to do, but Miss Becky said, watch his body language, and that made the difference. And I would submit to you that is simply not a finding that is justified in this evidence. It's not a finding that's justified under what we know about jurors, and it's not a finding that's justified by what the jurors said in this particular case. Now, to sort of detail my analysis in my free 5 minutes that I have here before the questioning comes, is we have 606, and we've got two issues. We've got number one is what happened. And then we've got number two, which is how do we analyze that particular issue? And when we start with what happened, that is obviously a credibility and fact-finding effort by the trial court. This court is very clear that the trial court, because this is not like a trial, this is a procedure that is in the discretion of the trial court, and ultimately any credibility findings, fact findings, this court respectfully would defer to. And so to determine that, what exactly happened? And this court ultimately credited the 11 jurors. And so what do we have with those 11 jurors? We have one juror saying that Ms. Hill said this is an epic day and the defendant is going to testify. All right. And then we have another juror who says, watch his body language. And beyond that, the court clearly did not credit juror Z. And I'll get into more about that, but there's plenty of the
Also, just want to say there's a reason why you never see body language experts in trial because it's bunk science. Just,
yeah.
So, for her to even be like, look at the body language. No, like that doesn't. Why are you telling people? I mean, people, yes, we inherently do give off body language. That is true. I'm not saying it doesn't exist, but like,
Yeah.
Come on, Becky. Oh, Waters. Missed you. The lawyers are just very eccentric in this case as well, which I enjoy.
Report in the record why the court could not credit what Juror Z said. Juror Z was ambivalent. Her answers were all over the place. None of the other jurors heard all those egregious statements. She couldn't even remember all of these egregious statements when she was on the stand. She said, I don't remember them. All of these things that really would take this analysis into a different level, she didn't remember. So when we boil it down to what happened, we're talking about epic day. All right, epic day, everybody in the courtroom knew it was an epic day. That is not news to anyone. Everybody knew it was an epic day. it is rare for a defendant to testify. That on its face is a neutral comment. That is not necessarily a comment one way or the other. And if anything, we've
False. I disagree.
6A, I disagree.
And that's because
100%.
they always tell the jurors whether someone, a defendant, takes the stand or not, you are not allowed to factor that into anything.
Mhm.
Even if it's a rare, again, it's little comments like this that cause a lot of problems
And by
in
someone
trials
who's
and hearings.
experienced.
Yes. And that's where the egregiousness
And that's why I'm
is
like,
coming from here.
she knew what she was doing.
Absolutely. Like, yeah, okay, it is in fact rare, but it shouldn't have been brought up at all. You shouldn't take into consideration that he did, or if he didn't. But
Savage just asked, who is Becky and what was
she
her
was
role
the
again?
clerk of courts. So pretty much at the top of the food chain
She's-
under the
yeah.
judges. So this is a very large position of power. If I recall, I'm pretty sure, but I'm not like 100% that she was also in an elected position.
Our clerks are elected.
Ours are too, and I think they are there too, but I off the top of my head, I don't want to say I'm 100% on that. But, so it's a very powerful position to be in. And therefore, we all unknowingly, subconsciously will follow people's things that they say when they're in a position of power. And this is kind of an abuse of power, because whether or not they consciously or subconsciously were influenced, yes or no, either way, it's hard to know. She was elected official. Okay, I thought so. It's been like 3 years. So,
Thank you, Demi.
parts of my memory are a little rusty, but anyway, I digress. So
seen where instances of a jury in deliberation considering the fact that a defendant didn't testify, saying, he must be guilty because he didn't testify. That's actually been an inference that goes more in favor of the defendant than against him, the fact that he's testifying. But again, it's rare that a defendant would testify. That ultimately is a neutral statement as well. And then watch his body language. Again, that is what was found, not don't get fooled by his comments or anything like that. That was not what was found by the trial court, just a neutral comment of watch his body language. And so that is the facts, the 3 facts that we have to ultimately assess. So
he's just quoting what the judge wrote in her order, which is interesting. I know we all have opinions about all of them, but they all do actually argue pretty well, including Waters. He does a pretty good job.
when we move on from there, then the analysis is how do we analyze that? And first of all, we have the discussion.
Neglect, right? Because we live in the same place. But yeah, right? It's like kind of super serious what she did here. Because when I got called for jury duty in the same county court, literally nobody will talk to you. Nobody.
Nobody was talking when I went.
You get a name tag that says you are a juror, even if you haven't been picked for a jury, you're just there for jury selection. And literally nobody will talk to you, except for like the one person at the desk while we all sat back in that's it. And you were instructed that if anybody said anything to you about anything, that you were supposed to say something about it, because it's that ability to influence is that powerful.
Like, she can't even say anything if she goes to the restroom because you don't know who's in the stalls. So the fact that she did it, she knew better. That's what.
Yeah.
I think
sure, you could probably have like daily banner, like, well, it's raining outside. Yeah. But regarding commenting on what's happening in the courtroom or will be, extremely unprofessional. Extremely unprofessional.
Of whether or not there's a presumption of prejudice. Justice Toll, of course, found based on this court's clear case law that there was not, but I would agree, I would submit to you that not only because of the alternative findings, but just because of a general analysis that regardless of who had the burden, that presumption of prejudice was overcome in this particular case. And I'll talk more about that in a second. But I think ultimately the legal analysis, whichever way you go, I don't think is going to be dispositive because of the relatively non-egregious nature of these comments. They are nothing like the comments that were in the cases that have led to reversal. So let's talk a little bit about more of the findings that were there. In looking at the evidentiary hearing that was done, we had, of course, Ms. Hill testify, and the judge found that she was not completely credible. We had Ms. Rhonda testify. The court did not credit that testimony because Ms. Rhonda conceded over and over again that she absolutely heard nothing whatsoever of
Mr.
any.
Waters,
Yes,
I want
ma'am.
to stop you right there, since
Oh.
your 5 minutes is up, and talk a little bit more about Jersey.
Yes, ma'am.
You're saying these are innocuous comments, not to be fooled, and look at his actions, look at his movements. The court seems to believe Jersey when she says in her affidavit and when she testifies that these comments were made to her. However, she goes on in her affidavit to say, not to be fooled, which I understood to mean Mr. Murdaugh would lie when he testified.
Mhm.
Look at his actions, look at his movements, which I understood to mean that he was guilty. The juror is testifying in her affidavit that the effect on her was significant. Why can the court, how can the court find that certain comments that she made, take them and incorporate them in the order, but not believe what she says about the effect?
Well, two things about that. I think that, first of all, Justice Toll did not credit any of the egregious comments that she didn't even remember herself on the stand, such as "won't get fooled." The only comment that was credited was what was testified by Juror P, which is watch his body language.
And let me, and I want you to finish your answer, but I want to ask you this. So far as the comments are concerned, are we limited? Is this court limited to only the comments that are included in Judge Toll's order? Or are we able to consider all the comments that are included in the affidavits, even the egg juror affidavit?
Well, what I would say to
That's an excellent, bravo on these questions for both sides.
I know. I was like,
this is
that's
why-
a good question.
This is why I love these, because they're very, interesting, insightful. Because she's saying, look, you're arguing the judge's order. That's it. What about the totality of everything besides just that? I
I'm
think
glad
that's
she
very
asked.
interesting. Yeah. Yeah. Aren't these fun? They're
These-
very fun.
I am liking this.
that is the case law is clear that the trial court has the discretion to conduct this hearing and ultimately make credibility findings, which under typical appellate law, this court would defer to. And so my argument to that is if you look at Justice Toll's order, both her oral order and her written order, she credited the 11 and did not credit Juror Z and did not give any credence to 741, the alternate, and or the egg lady, which of course did not testify. Now there was on page 808 of the record where she says, I think we've got in terms of what she says, Ms. Hill says, and what Ms. Hill says she says. That's on page 808 of the record and talking about the egg lady juror. But ultimately, I would submit that this court in appellate review does need to defer to credibility and factual findings of the trial court. And the trial court only found the 11 credible. And
Well, then help us understand the ostensible inconsistency when the trial court finds portions of Juror Z's affidavit credible and just carves out and
What they were.
doesn't deal with the part that dovetails with the alternate juror's testimony, which is far more prejudicial.
Sure.
How do we do that?
Well, so we're looking for, I would submit from an appellate court's standard of review, we're looking for support in the record for those findings. And so when you look at Juror Z, okay, and first of all, you look at the 11, which she did credit, and none of those 11 heard any of these other egregious comments or anything like that. None of
What do
them
we do about the order that doesn't even mention that Juror Z did in fact testify about the comment, don't let the defense confuse you?
Well, I think that when you look at the order in her specific paragraph on Juror Z, what she says is that Juror Z was ambivalent. And ultimately, as she goes through the analysis of what Juror Z says, she's not crediting that testimony. And again, I think there's support in the record for that.
There may be, and that may carry the day for you.
Right.
Assume that we find that that statement was made. Do you still have a path to victory?
That don't be fooled.
Oh,
At the end of the state's case, before the defense presents its case, the statement was made, do not be confused. Do not be misled by defense and its counsel.
Right. Well, I would say, and this is like everything in this, it is a question of degree. Okay. And there could, if the clerk could come in there and held a gun to their heads and said, you better vote guilty or I'm going to shoot you all, I probably wouldn't even be arguing that's not structural error. Okay. But everything is a question of degree. I'm not going to concede that if those statements were credited and are part of the review, that our path to victory is not harder. But I think you have to look at that in the context of this entire trial and when those particular statements were made.
And I think context is important. We all can cherry pick some of these that are on the surface innocuous. Epic day, big day. And when viewed in isolation, they don't move the needle, arguably. But when those seemingly innocuous statements are considered in the aftermath of the originating statement, not to be confused and misled by the defense, those initial innocuous statements take on a very nefarious message.
I could not argue otherwise, that it would absolutely be a question of degree. However, I don't believe that just ends the inquiry right there, because you still have to analyze it in the context of all of the factors and everything that went on. And so to look at that, let's look at all of the things, and let's assume that we're limiting it to what I contend Justice Toll found, which again, when I say innocuous, I'm saying relatively not egregious. I'm not saying that the clerk should be saying watch his body language, okay? But that is a far different comment from what you're talking about right there. But even if we add that in, we're still talking about a limited, number of jurors who saw that. And then we're putting that in the context of where that occurred. Okay, it occurred during the middle of the defense case, not during deliberations, not right before deliberations, but in the middle of the defense case. It occurred during, I think we counted no less than 60 times that this jury was told by Judge Newman to only, rely on the evidence, to not talk about the case, to not have external influence and all the rest of that. And we have to credit that. We also have to, again, put that in the context that when and if that occurred, and even assuming that there was a one bit beyond that it was attenuated from the actual point of deliberation by the rest of the defense case, by the entirety of the state's reply case, by all of the closing arguments of counsel, and by Judge Newman's very detailed charge. And so while that would be different, I don't think that is fatal when you look at the entirety of this 6-week trial. And again, go back to what I said ultimately at the beginning of my argument here is that for that to happen, you'd have to conclude that with all of that going on, with this massive evidentiary presentation, with multiple instructions from the trial judge, with all these arguments of counsel.
So you're distinguishing a day and a half long burglary third trial from this trial?
No, sir. But what I am saying is that I do think time matters. I do think,
but you would agree that at the end of a Berg third trial with a guilty verdict, the judge finds out that the clerk of court was back in the jury room saying something like, well, that defendant's not going to testify. But I just want to let you know, this is the 5th time he's been up here for a burglary third. So I just want you to know that. Egregious or not?
Your Honor, if that were the case, I would be very hard pressed to argue otherwise.
Okay, so help me out with this. If we craft a standard based on the length of a trial, and heavens know, nobody wants to try this case again. How do we create a standard based on a lengthy trial versus a day-long trial when the constitutional right is the same?
Absolutely, the constitutional right is the same. And what I'm not asking is this court craft a different standard for a long trial versus a short trial. What I am saying is what is relevant to the ultimate inquiry that this court engages in is the timing of when these comments took place.
Okay, well, let's talk about that. And I'll weave in some questions about the egg juror. Ms. McElveen, the Barnwell County Clerk of Court, said she didn't hear any of these comments made in front of jurors, but the comments made to Ms. McElveen by Ms. Hill were remarkably the same as those related by the jurors. For example, watch him closely, look at his actions, look at his movements. Ms. Hill was saying that to staff and to Ms. McElveen. You agree that's what she testified?
That's what
correct?
she testified to.
That does match almost exactly what these jurors said Ms. Hill told them, correct?
It is.
Okay. So explain to me how
Uh-oh.
we pass go under your theory. How do we accept the fact that Judge Toll maybe didn't mention all these things in her order, but they were supported by an impartial witness, that being the clerk of court from Barnwell?
Well, two things about that. I don't think we can get past what you've recognized, that clerk of court from Barnwell heard nothing going to a juror, or she would have brought that to the court's attention.
But the consistency of the comments or the similar nature of the comments is striking.
Well, and then my second part that I would say about this is that all of this arose months and months and months after trial. And the courts have been historically reluctant because of that passage in time, because of the fact that jurors vote one day and one day only, and don't have to assent to their verdict and vote him guilty every single day for the rest of their lives. And so I think that passage of time is something that is relevant as well when this case is being talked about incessantly out in the world. And so I think that that's something as well that Justice Toll can consider in deciding what actually happened. And the best evidence of what actually happened, and whether or not it is, whether you look at what the jurors said about it, not to get to the 606 aspect of it, or if you're objectively standing back and making that factual finding of this is what happened and this is whether or not there's a prejudicial effect. That is why Justice Toll credited those 11 jurors. And that is, I would submit to you, the realm of what this court needs to consider.
I want to ask you a question about this idea that you expressed, that this event or these moments when the clerk spoke to the jurors should be considered insignificant when viewed among the entire trial, whether it's long or short trial. There's no eyewitness, there's no DNA, there's no one thing on the part of the state that you could rely on to show him guilty. So you had to piece together a whole bunch of different stuff. We'll talk about a lot of that stuff in the next phase. But
yes,
but you spent, most of that 6 weeks was you piecing together small pieces of evidence to put together an argument that he did it.
Mm-hmm.
On his side, now, of course, he doesn't have the burden and isn't even required to testify.
Mm-hmm.
But on his side, whether he's guilty or innocent boils down to one moment, one thing. And that's when Alex sat up on the stand and said, I didn't do it.
Mm-hmm.
So what I'm wondering is, you're wanting us to consider the statements by the clerk to be insignificant, but those statements go to the only thing that the defendant really had. I mean, the defendant can argue that you didn't piece it all together, but really the defendant's argument boils down to the one thing that the clerk of court addressed. So we can look at all this context if you want to, but the jurors knew that if Alex was telling the truth, he's not guilty. If he's lying, he is guilty. And that's where the clerk of court's statements appear to focus. How do you respond to that?
Well, I would say that while I understand that obviously was very important, the defendant taking the stand, it wasn't as simple as just getting up there and saying, I didn't do it, okay? And while there was a long piecing together of all of that, the defendant's testimony was also very long over the course of 2 days. And so I don't think that you can just view the defendant's testimony entirely in isolation of this entire trial. I don't think any analysis that has ever said that we're going to ignore the entirety of what went on. Certainly the defendant's testimony was important, but they had been raising all kinds of issues as to lack of motive, as to other possible motives, as to the boat case.
So you can check him alive.
The Cowboys and all these other things along the way as well. So again, saying this is an epic day, saying it's rare for defendants to testify, those were all statements that everybody in that courtroom knew, everybody in that courthouse knew. So while I hear what you're saying, I think that you can't take out the fact that this was a complex matter with a lot of complex issues.
And, to the extent though, you've made some fine points about how we should interpret the statements. But if the statements, as in Justice Kitchens was alluding to this, if the statements kind of collectively go to the point you should not believe him, to me, it's hard to separate that from the critical issue in the case.
But I want to bring up one other thing. You point out in the very beginning of your argument that the trial court here found that Becky Hill was not credible. Now that's a soft statement. That's almost like Richard Nixon or Bill Clinton, whoever it was, said mistakes were made. Sometimes people are not credible because they didn't get a good look at what occurred. Sometimes people are not credible because they don't remember what they saw.
Right.
Here, if Becky Hill is not credible, it's not because she didn't see it. It's not because she doesn't remember it. It's because she's a liar. Is that right?
Oh, shit.
I would say that ultimately she said she was not completely credible. And yes, sir.
So there's only one way that Becky Hill can be not credible, and that is that she is a liar.
I think that Justice Toll did not credit parts of her testimony as she looked at everything. Now, she didn't specifically find that she is a liar, but ultimately she didn't credit that testimony. But what I think is important is that neither Justice Toll nor the state relies on Becky Hill. What we rely on is what is most important, and that is the 11. The overwhelming majority of these jurors who sat there and looked Justice Toll in the eye, who judged their demeanor, who judged their credibility, and who ultimately were clear as a bell that there was no sort of improper influence on their verdict. And when you look at these questions and you know, whether or not they went beyond 606B, ultimately they were questions about impartiality. And I think there's a distinction, and Justice Toll made this distinction that when she phrased these questions, first of all, she had the 4 exact questions that were in green, which I understand the footnote, Justice Hill, when you were on the Court of Appeals, but they were the same 4 questions from the record in State versus Green. So that was a reasonable set of questions to ask. I see I'm out of time, but
You premised your response that she relied on 11.
Mhm.
In Ethier, this court overruled Vestry versus Orkin exterminating, and that a party is entitled, and that was a civil case, 12 impartial jurors, not 11.
yes, sir.
So how do we deal with that?
Because ultimately the 11 were credible and Z was not. And that is what Justice Toll clearly found. And when we look,
And how do we handle Miss Hill with, as I think Ms. Harputner referred to one of the comments, that Miss Hill was attracted by the siren call of celebrity.
Siren.
There's another quote in the trial court's order. She allowed her desire for public attention to overcome her duty to her oath of office and her oath as a witness.
yes, sir.
How do we deal with that and pick and choose what parts of her testimony we accept or don't accept? We just refer to the trial court.
Well, I think when we look at Ms. Hill, and again, I'm not here to justify or to defend Ms. Hill. Ms. Hill, of course, said she didn't do, any of these things other than, occasional, just everybody pay attention, you need coffee and things like that. But so I think that ultimately Ms. Hill is she didn't admit to any of those things. So you have to look at Juror Z. Juror Z is what's really in play as to whether or not Ms. Hill went beyond what we say and what the trial court found was the area of what this court is to consider, and whether it was something far more egregious. And even beyond that, even if you take some of what Juror Z said, even if you take some of what Miss Becky said, even if you take some of what Miss Rhonda said, when you do that analysis and you put it in the entire context of thing, and when you put it in the entire context of this entire trial, and you put it in the context of where it occurred and everything that went on after that point, then the state has overthrown. As Justice Hull said, she finds it. She did not find that a few foolish and fleeting comments in the entirety of this trial would be enough to have infected this verdict and to make it unfair. I completely agree that somebody's entitled to all 12 jurors, but this is a credibility finding that 11 told the truth and 1 did not, and the 11 set the standard of what this court should consider, and those comments were not egregious.
Please, yes, sir, Justice James, and we may have some other questions as well. Just
I've
one
got-
second,
I've
please,
got
Mr. Waters.
A few. You go ahead.
No, you go ahead.
the jury of 11 versus 12. In the defendant's brief, he argues that Judge Toll studiously avoided Parker versus Gladden.
Mhm.
And I think that's the case where it took a vote of 10 out of 12 to find somebody guilty.
Correct.
Who did they say?
There
what?
is no mention of Parker versus Gladden in this order. Is that still good law?
Yes, sir. And I'm not.
Okay,
continuing
so, but you said several times, and I would too if I were you, that 11 jurors said, no, my verdict was my verdict.
Right.
So that takes me, I just want to, you can respond to the Parker versus Gladden part in a moment, but you also need to explain to me about the egg juror. She was removed from this jury on the day deliberations began. Is that correct?
Hey, Anna.
Yes, sir.
So she was not an alternate. She was a sitting juror.
Correct.
And so she was there and removed minutes before they began talking about the case, began deliberating, correct?
Correct.
And she said in her affidavit, that her ex-husband called her as she was getting on the bus to ride to the courthouse that morning. That upset her because she had a restraining order prohibiting him from contacting her. So she called or she spoke to Ms. Hill, correct?
Yes, sir.
And Ms. Hill told her, according to the egg juror, the Murdaughs probably got to him. You agree that's what she said in her affidavit?
That's what she said in her affidavit.
Okay. And then Ms. Hill asked her if she was leaning one way or the other. And the egg juror said, Mr. Waters' closing was good, but I still have questions. And she said, what kind of questions? And she told Ms. Hill she had questions about the guns. I suppose couldn't find them or there were two used. And then Ms. Hill asked her, what makes you think he's innocent? And she said, the video at the kennels. And then she said, Ms. Hill said, everything the defendant has said has been lies, and you should forget about the guns. They will never be seen again. Are those fleeting comments or are those egregious?
Those are great.
Your Honor, those would be hard pressed to defend. Yes, sir.
Okay.
That would be much different from when I'm arguing this record.
And then Ms.
reflects.
Hill told her that the full person should just go in and ask for a raise of hands, and this will be over and done with, and everybody needs to be on the same page.
It was done and over with in 30 minutes.
Yeah,
By
but
the
you
way.
can't say that.
No, you can't. Also, fun little Easter egg in our Couch Court with Llama intro at the end, in case you didn't know, the bring the jury. That would be Judge Newman from the Murdaugh trial. It's our little Easter egg for all our former trial watchers. Anyway, sorry.
Goes along with the
I was
egg juror.
struggling, number one, with why the egg juror wasn't allowed to testify, because that was directly impeaching of Ms. Hill's testimony that she said nothing, correct?
Yes, sir.
Can you pause it for a
And
minute, Lana?
Judge told
Sure.
And maybe it's just me and I am Southern. I have a problem with the attorneys saying Miss Becky and Miss Rhonda
Oh.
because it shows that they they personally know them
Hmm.
and it infers a relationship, and I don't like it. So I'm just saying that I prefer them to be called by Miss Hill, Miss whatever. So
Well, like as I said earlier, there is corruption
I mean-
all over the place, in my opinion. But
it is the backwater.
but that's also kind of like what you guys do, though. I guess I don't know.
But yeah, like I didn't approve of them calling Murdaugh Ellott or whatever it was.
Alec.
Yeah,
So,
it should be.
well, what's interesting is like none of the people actually worked for that county that was in there. Like Waters
Yeah.
was brought in as a special prosecutor by the state. Both the defense are
they
local.
all-
Judge Newman wasn't the local
all
judge.
know each other.
Yeah, I mean everybody knows everybody is what I've learned from this case.
Yeah, I mean,
Mhm. But those, that's just all. Oh man, Becky.
I mean,
Yeah,
I almost feel like somebody was picking and choosing what they wanted to let in.
that's what the
maybe
judges are implying.
I'm talking about Toll.
Yeah. No, that is pretty much
You're
what they're arguing.
It's not like you today.
It doesn't. I don't understand what its deal is. Like he's trying to like switch to my computer one instead of my actual one, but whatever. I'll deal with it later.
Buffy, I agree. Everything is casual in that court, it looks like. Agreed.
Very much so. We'll do a different background. I don't know why it's doing what it's doing. I'll be look at it later.
Oh, I hope y'all didn't. Did y'all hear that?
Uh-uh.
Oh, my stomach
No.
just rumbled really loud.
I might have missed up with the setting because this weekend I was just working in my bed. And so I had unplugged all of my everything that hooks up to my laptop. So it might be like a me. Like I didn't hook or rehook up something. I don't know. Who knows? It's fine.
Did say that the egg juror's affidavit is in the record, so we know what she said, Ms. Hill said. So can we consider that affidavit?
Ultimately, I think that Justice Toll, when she made her ruling on, and again, within the discretion of the trial court, as the case law allows her to do, to set the tenor of this inquiry, was only looking at the jurors who actually deliberated. And I think ultimately we got to the alternate because the alternate was there to the end. The difference with the egg lady, and we have to remember this too when we look at the implicit rejection of all of that, is that the egg lady was, and it wasn't like she just got kicked off that morning. That was the product of a couple of days of in-camera hearings that ultimately disclosed that this egg lady juror, who initially said she had not talked about the case, it was ultimately discovered that she had. And all of this stuff about, the Facebook and all that other stuff, Judge Newman was very clear was not the basis for her removal. It was the basis for her removal was her violation of when
somebody delivered a refrigerator.
Correct.
And they said she was talking about the case.
That's correct. And then, and that was after she denied it. And then ultimately it came to pass that was not the case. And Judge Newman removed her, frankly, for that misconduct. And so that in and of itself is supported in the record as a basis in the record for Justice Toll's rejection of the credibility of all of that. And this is a person, again, who wrote a book afterwards, and months of going on when all of this stuff started percolating up. I think that's all relevant to consider as well.
Justice Hill.
Wait, did Egg Lady buy a book?
I know. I was
Or
like,
write a
did
book, or is he
Egg Lady write
talking
a
about
book?
Becky?
I
don't know. I don't know anything about it.
Mr. Waters, you talked a lot about the timing of this case and the length of it. Now, the clerk is the public official who jurors have their first contact with from the courthouse and their last. She's the administrative face of the court, essentially. Her name's on the letterhead of the jury summons that the jurors get. She swears in the jurors. She swears in all the witnesses as they're about to testify. She coordinates the juror schedule. She's the liaison between the court and the jury. She's their guide or their Sherpa, so to speak. She's their point person. And she reads the verdict. And she signs their paychecks at the end of the trial.
That's power.
Their paychecks for $50.
That's power, though.
But yes,
that's power.
It is. I did not know the Egg Lady wrote a book. But also, I would argue, because one, it's not, a lot of people write books that have been involved in this sort of stuff. But Becky's problem with her book was the pre-discussion of it ahead of time.
Right.
Egg Lady didn't even know she was going to be picked as a juror. So, that's interesting. No, I'm not arguing with you, Buffy. I'm just for the court's sake here. That's interesting, though. I did not know that she wrote a book. I guess I'll have to read that one too, just out of fairness. Don't even get me started on Becky's book, you guys. Oh. Anyway.
Now, justice is supposed to be blind. We all know that. But court officials, when it comes to the merits of a case, are supposed to be mute. That's the ideal. That's the aspiration. Even our Constitution prohibits the trial judge from commenting on the facts of the case in open court.
Yes, sir.
Now, after a 6-week trial, it's only human nature that these jurors might become bonded to this person. So you've talked about the timing, and I'd like to talk about the source of these comments and where they occurred, which was in the jury room. So can you comment on that?
Yes, sir. So I
blindfolded for a
hear what you're
reason.
saying. I think, though, that maybe overstates, and I don't at all distinguish or disagree with you about what a clerk should do and the role that they serve and all the rest of that. But I do think that overstates what is supposed to, what Justice Toll was supposed to do and what this court is supposed to review, and that is the specific circumstances that occurred here. And I think that maybe overstates Miss Becky's sort of influence in all of this at this point in time. The jury, actually, the person who handled the jurors day to day was Bill Polk, not Miss Becky. And in fact, as Miss Rhonda testified, Miss Becky got sick, and Miss Rhonda was at the trial more than Miss Becky was. And so while certainly some of those factors may exist, I think when you look, and this is what I argued before, when you look at what was going on in this courthouse, when you look at the entirety of the specific facts here, when you look at Judge Newman on the stand, it was really, if you want to say the Sherpa, the shepherd of these jurors is Judge Newman, not Becky Hill. When you look at the entirety of this record, I don't think that, while you're exactly right that the clerk has that neutral role and serves those functions, that in this particular instance, Miss Becky's influence was that large, and there's no evidence of that in the record. And to go back to what Justice James was saying is, this is part of the rejection of that credibility, that all of those detailed things just so above and beyond the pale that the egg lady says happened, and all of that contact, no other juror said anything like that. And those were the jurors that Justice Toll found credible. And again, that has support in the record that Miss Becky has just decided egg lady of all people is the person that she's going to go through all of this with, and not have similar conversations or similar things like that with all of these other jurors. And again, that in and of itself is support in the record for us to put those aside and focus on what the 11 said. Not that 11 is good enough, but that 11 are credible, and that rejects these claims of the others that all have credibility issues that have support in the record.
The circumstances of this issue are not lost on us. In the courtroom, we have an excellent attorney general with a very professional and competent team of prosecutors, including you, Mr. Waters.
Mhm.
On the defense side, we have an extremely competent, top drawer representation. We've got a superb trial court judge.
Agreed.
And out in the hallway, we have a rogue clerk of court. And even if we accept the truncated version of what you characterize as innocuous statements, even you acknowledge it was improper. Perhaps not improper to the point of reversal, but you acknowledge it was improper.
Absolutely. And if I could respond very quickly.
Well, I want to make the note, because in my position as Chief Justice, I have to deal with the clerks of courts in 46 counties. And the overwhelming majority of our clerks of court are dedicated, conscientious public servants who discharge the duties of their office with integrity and do not act like this. And I'll give you the final word.
Thank you, Chief Justice. I think what you just said highlights and proves my point when you went through all of the players in this trial and the relative insignificance of Miss Becky. And as I said before, with all that going on, that some jurors really like, oh, well, Miss Becky said, watch his body language, that is going to make the difference. What you just said of all that went on is why, not the truncated version, and I understand your point with that, but what the record reflects and what Justice Toll found is what really happened. That was the extent of it. I don't mean to imply they were innocuous. What I mean to imply is that they were neutral on their face, not proper, but neutral on their face and not egregious.
Thank you so much. Appreciate the fine arguments on both sides. At this time, before we go to you can do the reply now on this issue? I thought we can do the reply at the end. What was your understanding, Mr. Barber?
Chief Justice, if the reply would be at the end of it.
Okay.
That's mine too. So we'll take a, say, 10-minute break. Everybody stretch their legs, restroom break, and then we'll be back in 10 minutes. Thank you.
Hold on.
I am loving this.
Isn't it something? Hold on.
Yeah.
Sorry, I'm just grabbing a new drink.
Thank you, BC.
Yeah.
'Cause, All right, sorry.
I have a problem with him thinking it's not a big deal.
Well, they don't want everything to be overturned.
I know, but
but it is very much a big deal. Even the justices are kind of obviously like this is a serious problem here. And it's unprofessional, and it's just not great. Because again, even even if, it doesn't matter his guilt, innocent, anything on trial, all because of what one person said and did and took their, opinions and thinking that they're important. And here we are, and it's just like Becky knew better.
She knew
As
better, but think if some of these jurors, I don't know what their skill
Mhm.
set was. What if not just not knowing courts, not
Yeah.
knowing law, but if you're, and I don't know the better word to use, but someone who's not very well educated there in, the back country.
Well, even,
They're,
I mean, just educated at all in court. Most civilians are not, right? You don't know until you're in
but I
it,
mean,
quite frankly.
even somebody who maybe only graduated
Really?
high school, hasn't worked, hasn't had life experiences, I guess, I think that person is a person of power.
Yeah, absolutely. I mean, yeah. Also, I mean, as I said, like, I thought trial-wise, I thought everyone was really good on both sides. I thought the judge was great. I thought defense was great. Prosecution, I thought was great, except for that one guy that's on there, and I don't remember what his name is. He was a blubbering idiot on the state side. I do not remember, but anybody that was watching knows who I'm talking about. I just can't remember his name, but, that's the thing. All this hard work went into it, while it doesn't and in the end, it doesn't matter. Doesn't
Right.
matter because
Because
Becky didn't shut her mouth.
she's
Becky
right.
thought saying things out loud constantly, whether or not it influences them, it's too egregious that it's
Yeah.
you can't
It has the
look past it.
sniff of impropriety.
Well, yeah, I mean, he wants to focus on all these, "Oh, it was an epic day," whatever. Those are not the problematic comments.
No,
The
but when you
problematic
put it with
comment
everything else, it makes it even more.
being watch his demeanor, implying that he's lying, his team is lying, all of
Mhm.
that, which again, a juror can come to that conclusion themselves.
Right.
A lot of people do, but that's the thing is can even they differentiate whether or not that was their original thought or was it influenced subconsciously
And you
by
came
Becky?
in with this already preconceived, oh, I shouldn't really pay attention to them because they're lying.
Mhm.
Yeah.
Exactly. Exactly. But yeah, Supreme Court appellate hearings are very interesting like this because they're not here to argue, other parts of the
Oh,
case.
no. Oh,
Um,
lady in gray,
so
that's not what I was saying. What I'm saying is a person who doesn't, and I didn't mean educated by books. I couldn't think of the word to use, but people don't have as many life experiences would look to that person as somebody in authority. And I think you would take their,
well, and for guidance,
yeah, I
you
mean,
know, I would anyway, right?
because I have to be honest, when I, went on a jury summons I got many, many years ago, I remember going up and asking somebody, okay, what do I need to do? What do I need to expect? What? Because I had never been there.
Mhm.
And that was when I was called to be on the grand jury.
Mhm.
If just imagine if Becky would have been my person and she'd have been like, oh, you do this, this, and this. Oh, and just don't pay attention to what his side said and watch his body language. I
Well,
would be all like,
yeah, I
what am
believe
I going to
some
say?
commented after the trial that that's kind of exactly what happened and made them feel like, right? Was like they didn't know that it wasn't allowed. They didn't know it wasn't normal because why would they, right? She's in a
Right. Because
position, she knows what she's doing. I'm gonna sit there, I'm gonna think, oh, this is normal until they found out, no. No, actually, that's against a lot of
yeah.
rules and ethics
And
and
that's what I meant
decorum.
by being
So,
educated with the legal system, what's right, what's
yeah,
wrong,
because
and life experiences.
you don't even have to go to school for any of that, right?
No.
At all, at all. But when somebody is in that position, just like if a judge were to do this,
Oh,
another attorney, anybody, that
well,
is very influential.
they know more. It's their world. Yeah.
Don't worry, Boots said that. Boots said that in the trial. Well, I may live in the big city, but I'm a small town country
That's country.
lawyer, which he's not. Uh, but as far as the trial goes, while I said, yeah, the state didn't give me enough, quite frankly, for that to have been my verdict, I felt like compared to how we've seen some other trials of, some questionable behavior on prosecution, I didn't get that really in this trial,
Yeah.
near as much as others. Excuse me. Was there a political reason to do this? Absolutely.
Oh, absolutely.
But again, all the parts were not from that local area, which is really important I thought, to the case. And I don't know what my camera deal is, but whatever, it's fine. So anyway, I'm really glad you're enjoying
I
watching this.
am.
It's very interesting, isn't it? Now they're going to go into phase 2 of the hearing.
My nails are too long.
We move to phase 2 of the oral argument. Mr. Griffin,
like
are you
Marvel.
arguing the evidentiary issues?
I am, Your Honor.
We're ready to hear from you, sir. And good morning.
And I will say this for all sides here that are arguing, this is incredibly tough for them all to do. And even Waters is doing a very good job. I'm not going to shit on Waters, even though I respectfully disagree with him. It takes a lot to be able to do what they're doing here. It's quite impressive.
Yeah. I'm intimidated just watching them.
Yeah, I know, right? Like,
I'm like,
ooh.
I wouldn't even want to be sitting in the court for that because I would be intimidated that I would say something or do something wrong.
Yeah, no, they're both sides, I think, are doing a fair. I mean, I don't necessarily agree with Waters in what he's pointing out, but
Yeah.
he is doing a fantastic job of being able to think on his feet and keep
Mhm.
it directed on what he wants them to look at, and it's impressive to me.
And he's
what do
doing
I
what
know?
he has to do for his job, you know?
Well, yeah, I mean, to some degree, he doesn't have to, but here we are. If he's going to do it, he's
He's going to do it.
there. But yeah, a lot of lawyers will tell you this is probably one of the most pressure positions to find yourself in as an attorney, is going in front of a Supreme Court of any kind. So
Chief Justice Kittredge, members of the court, I'm Jim Griffin. I'm here representing the appellant Alex Murdaugh. This appeal presents 5 fundamental evidentiary errors that individually and cumulatively denied Alex Murdaugh a fair trial. First, the court admitted testimony from a cell phone forensic evidence who confessed that he had never actually done a physical experimentation like the one about which he testified,
mhm.
knew nothing more than anyone else in the courtroom.
Remember that? He just threw his phone.
Yes, he just
Y'all remember that?
I forgot about that. Shit.
Mm-hmm. Just, I threw it. And that's what it did, because that's apparently how science works.
That's how it works.
Not great.
The court admitted gunshot residue evidence from a blue raincoat, despite the fact that the only connecting witness definitively testified that what she saw was a blue tarp and could not be confused with a rain jacket.
Also, in case you don't know, gunshot residue evidence is being thrown out of courts all across the country. A lot of states don't even allow that kind of testimony anymore and have deemed it bunk science. Just put that out there. Iowa is one of those states. I watched a trial there where it got GSR residue. Not great. More and more are getting rid of it. So I think that's interesting.
3, the trial court admitted unfairly prejudicial evidence over 6 days regarding financial crimes spanning 6 years, the crimes that were committed by the appellant. 4, the prosecution violated Doyle v. Ohio by repeatedly impeaching Mr. Murdaugh regarding his post-Miranda silence after being arrested on the murder charges. And 5, the court admitted firearms identification testimony based upon unprecedented methodology that the expert himself could not state to any reasonable degree of certainty during the counsel hearing. In the interest of time on that 5th issue, I intend to rely on the briefs unless the court has any questions about that evidence. The evidence in this case did not conclusively prove defendant's guilt such that no other rational conclusion could be reached. Therefore, none of these errors were harmless beyond a reasonable doubt. There were no eyewitnesses to Maggie and Paul's murders. The murder weapons were never found. The forensic evidence does not support Alex's guilt. All crime scene criminologists, experts testified that whoever shot and killed Paul shot him in the head, his brains hit the ceiling,
and blood and brain matter would have been on the guns and on the shooter. That was without a doubt. And there was no brain or blood matter found on Alex's person, his clothes, inside his Suburban, inside his home. They checked the bathtubs, nowhere. There were trace amounts of DNA found on Alex's clothing that were consistent with his explanation that he checked them for signs of life. There was minimal GSR, gunshot residue on Alex, which also was consistent by the SLED's own testimony, consistent with him going back to the house, getting a shotgun for personal protection and waiting for law enforcement to arrive. Alex Murdaugh's interactions with others after he left the kennels that night and before he returned and called 911 was normal. He talked to his son Buster, he talked to his brother John Marvin, he talked to another lawyer, Chris Wilson, about the case. They all said his demeanor was normal. Visiting his mother, there was nothing out of the ordinary about his demeanor. There's no time of death established. The coroner did a finger test under the armpit. The state relies exclusively on cell phone data inside the phone to establish a time of death, which was unreliable in our opinion. The cell phone data showed at 8:45 p.m. there's a kennel video, and Alec had lied about previously in his interviews about being at the kennel with his family. But there's a kennel video at 8:45. There's nothing on the video that would lead someone to believe that there's a murder about to happen. It portrays a normal family. At 8:49, Paul used his phone for the last time. It had very little battery left on it. At 8:55, there was some action on Maggie's phone. And at 9:06, Maggie's phone registered movement for the last time, some 20 minutes after Alec testified that he left the kennel. We submitted an expert on acoustical testing, and it was uncontradicted that if you're in the house with the door closed and the TV on, air conditioner on, you could not hear gunshots down at the kennels. And then Alec's testimony himself denied killing his wife and son. So this was not an overwhelming evidence case. This was a very close case. And the cell phone and GPS data, frankly, pointed to his innocence, not his guilt, as I will explain in a moment. And that brings me to the first issue that I'd like to address, is that the state was allowed to present expert opinion testimony about a test that was done during the middle of trial from a cell phone forensic expert, a deputy from Charleston, who had previously been testified about chain of custody and other issues.
It's unbelievable.
During the weekend after our expert testified, and it's critical to know that Maggie's phone was found on the side of the road about a quarter of a mile down Moselle Road and 15 feet off the side of the road. And when we finally got the GPS data during trial from General Motors and the OnStar data, Alec went by that location doing 42 miles an hour at 9:08 p.m. As I mentioned earlier, Maggie's last phone activity, orientation change in the phone, was at 9:06. The question is, if Alec had thrown the phone out at 9:08, would it have registered an orientation change? Would there have been anything in the phone to record him tossing the phone out? And the testimony that the defense presented was, Mika Sturgis talked about the rise to weight feature. He did an in-court demonstration. I was going to bring my phone up here, but if you just lift it up, it lights up. All of us have.
What's your theory as to when the phone was tossed out of the window of by someone? What does the timeline show? I take it your argument is that when you toss the phone, at some point it's going to the raise to weight feature will activate. So my question is, on the timeline that we have, and it's extensive.
Right.
What is your theory as to when the phone was tossed?
So Justice James,
Kind of, but not really.
with all due respect, I want to rephrase it. I think that's asking the wrong question.
Okay.
I think the right question is, would the phone turn on and record any sort of activity if Alec threw it out the window at 9:08?
So Poot was there to argue the Becky Hill stuff. Jim is arguing additional appeals from the case, such as this scientific thing that was done over the weekend that should never have been allowed, such as them questioning Alec when he was on the stand Well, why didn't you say anything to the cop? Which is, you're not allowed to do that. All right. You have a right to remain silent. That's a constitutional violation for them to have said that during the trial. So Jim here is arguing some other appellate issues here. It's the difference for the two. So why did this not notify you? Probably because YouTube is just, it's a Monday. Why not?
YouTube's
So-
YouTubing.
So here's some more why they think, egregious things that happened during the trial, to which these were my points too when I was watching them for most part.
I know you say that, but I'm talking about in the timeline that we have and the cell phone extractions that we do have. When was the phone tossed?
And
Well,
this is what
I
I'm
mean,
looking forward to in the second
I mean,
trial.
the states, so you could say one explanation, it was tossed at 9:06 because that's when it registered. Or you could say at 9:06, it was down at the kennel. Well, we don't know. Honestly, we don't know. We don't know how it got put on the side of the road. There's no witnesses. But what's so critical to our defense is that at 9:08, when Alex Murdaugh goes by that exact same spot at 42 miles an hour, if he had thrown the phone out the window, what would have happened? And the state says they were just replying to our expert, Mika Sturgis, who said he's not qualified to say whether the light would come on or not, whether it would register anything.
Similar question. I don't
Aw.
think you have to have a theory. That's the state's burden. But when
Okay.
we're looking at your argument that Alec didn't throw the phone out when he drove by because it didn't light up, that raises the question of how it got there. Somebody put it there,
Without no
and
doubt.
it never lit up. So the point that you're making is it's wrong for the state to be able to prove that it might not light up. But to me, it looks like it definitely didn't light up because whoever put it there, unless it was at 9:06, the phone did not light up. So I'm raising the question of whether this even makes any difference.
Well, it makes tremendous difference because if Alec threw the phone out at 9:08 when he goes by that location, our evidence, not through our cell phone forensic person, but through our accident reconstruction acoustical guy, Mike Sutton with Accident Reconstruction Institute in Raleigh, North Carolina, says that phone at 42 miles an hour will tumble. And when it tumbles, that raised the wake feature. So we did put in the evidence through two witnesses, both qualified, about what they testified.
I got that, but let's just hypothesize that Alec didn't do it. He didn't have the phone in his hand when he rode by at 9:08. Somebody came along at 9:20, these roving marauders, you call them or whatever, and they killed the Maggie and Paul. And then they were responsible for getting the phone to where it ended up. Wouldn't the phone have lit up then?
It depends on how it was placed there.
If we don't know whether it would have lit up then, we also don't know whether it would have lit up at 9:08.
Well,
That's why I'm asking why this even makes any difference.
Here's what we know at 9:08. Alec car is going by that spot at 42 miles an hour. Did the marauders go by and pull over?
Maybe.
Were they walking? I mean, we don't know. There is no evidence in the record. What there is evidence in the record is he went by that spot at 42 miles an hour, didn't slow down, didn't speed up. And if he had tossed the phone out, it would have tumbled. And all it has to do is go upright and the rise to wake feature would come on. And so to combat that, they had a guy sit around the weekend throwing a phone around his office from Friday
You
and Saturday.
cross-examined him very thoroughly, and said, he said he recorded nothing about his experiment. He wasn't an engineer.
He
He
testified about
didn't
it.
know more than anybody else, and he didn't testify to anything you couldn't look up on Google.
Yeah,
So
that's
how
problematic.
what's the harm in that? I mean, your cross-examination seemed to be very effective.
Well, the harm is the expert opinion he was allowed to express that says it was possible that the phone would not illuminate if thrown from a vehicle going 42 miles an hour. The harm was when Mr. Waters gets up in this closing argument and says, Paul Manigault got up here and testified as to the issues and to the fact that there's no guarantee, more likely than not, if the phone is violently thrown or flipped out or whatever, it's going to light up. I mean, that was critical to their defense to address our exculpatory evidence that we went by there at 42 miles an hour. And if we had tossed the phone out, it would have shown something. If they wanted to test that, they needed to put an expert in a car doing 42 miles an hour, throwing it out the window, and then checking the phone to see what happens, and do it multiple times. But you don't sit around an office as if you're playing cornhole with a beanbag all weekend, and then come to court and say, sometimes it lights up and sometimes it doesn't light up. And therefore, I conclude that, it's more likely than not, it wouldn't have lit up if Alex Murdaugh went by there at 42 miles an hour.
This is
Now, I'll say this because this again is part of the second trial that I'm really looking forward to, is exploring more of the phone data and what it means and what it doesn't mean and what we don't know that it means. Because, and I'm going to, Karen Reed really shone a light that many of this data is used a lot in trials. And so if we're saying here, well, you know what, it doesn't matter if it light ups or not, it doesn't matter. Well, then why does everything else about the data matter if it can't be consistent, right? Like we are, and the reason I feel it's important is because we are talking about, this is a very serious case, right? Somebody two people unfortunately have died. Somebody is spending their life in prison for this. We can't just do, well, sometimes it does this and sometimes it does that, and we just don't know. If we don't know, then I don't think it should be used.
Agreed. Uh-oh. We just lost Llama altogether. But she's back. I agree with Llama. If you can't determine 100%, it shouldn't be allowed in my opinion.
Well, and this leads to people really want to believe the hard data of things, of course, right? And so when you have somebody on the stand that is saying things like this, well, they need to be careful where they're putting their eggs in the basket, for lack of a better word. So I'm very interested to see how this is going to play out in court, because it didn't play out that great. And we do plan, I know we've talked about re-listening to some of the different witnesses. So we plan on doing some of that while we wait for the actual trial to happen. Go back, re-listen, to the data witnesses, all of that. I think would be really.
But yeah, she had to get the egg thing in there. The other thing I learned with the Karen Reed trial and with their experts, that stuff can be manipulated and be left to interpretation, and therefore, I am not confident. If I was a juror today or anytime in the future, I wouldn't be confident now that we know it can be manipulated and interpreted.
Yeah, absolutely. I mean, those of us that watch trials on the regular, like Karen Reed, almost we were like, whoa.
I know. I was like, I had to reach out to my guy that does forensic stuff on phones. I was like, really? And he's like, unless it is done a certain way, you can manipulate the data. That to me tells we don't trust
pay
it.
attention to certain things here and there,
and not others.
So, I mean, we'll see, how they do. But anyway, that's that one. But yeah, I remember that guy. He was like, "Yo, I just threw it." And it's like, well, that's not the same as a freaking going 42 miles an hour, sir. But all right, I'm going to play this because he's calling me.
Certainly an unconventional moment at the trial. And, I was reflecting back on 10 years of trying cases, none of which were 6 weeks long. And, in the state's reply, everybody's tired. Everybody's ready for the case to go to jury. It's almost like there's this unwritten rule of evidence that at that point in the trial, you can pretty much do whatever you want. But the question is, what did they do? And you're saying when they stood up to speak to Judge Newman, they said, we got an expert. In their brief, they talk about it simply being an experiment. Judge Newman listens to all this and he calls it an experiment. He doesn't call it expert testimony. He says, page 6721, he did not provide scientific testimony. He conducted an experiment and told the jury about it. And I'm just wondering, do we really need to go through a 702 analysis here, or should we be talking about the admissibility of an experiment?
Well, I believe this court's opinion in State v. White in 2009 that Justice Kittredge wrote, there's no distinction between, so it's an opinion testimony.
Well, that was an opinion. That was an opinion based on the work of a drug dog.
Right. So, and here we have an opinion testimony that when Alex Murdaugh goes by that location at 42 miles an hour, it's the light may come on, may not come on. More likely that it won't come on. So that's the opinion testimony. And that is whether it's scientific or experience, it doesn't matter under the analysis, but it had to be proven to be reliable, and it wasn't.
Mr. Griffin, I'd like for you to address the 404B issue, if you don't mind.
Yes, sir.
Do you believe any of the evidence about the defendant's financial crimes could have been admitted under 404B as motive evidence?
No, not a bit, Your Honor, not as motive evidence.
And I have some questions, I'm sure we all do, for Mr. Waters in terms of the expanse that was allowed under 404B. Well, what about like Ms. Seckinger's testimony, for example, on the day of the discovery of the theft of the Ferris fees? What about the impending motion to compel hearing in the so-called boat case a few days later that would have arguably exposed the extent of his financial misdeeds? Why wouldn't that have some relevance for 404B motive purposes?
Well, we have the benefit of extensive in-camera hearing, well, not in-camera, but hearing outside the presence of the jury, and where all of these matters were testified to. And Ms. Seckinger said that on June 7th, she went to confront Alec about, this Ferris fee. Now, understand this Ferris fee is a one-off situation from all his other scams and schemes. This was attorney's fees that were due to the law firm that he diverted to himself. That's the Ferris fee. And that's what was their concern. And their testimony was they weren't concerned that he was stealing money from the firm. They were concerned that he was hiding money from civil discovery from the boating case. And they didn't want any part of that. She also says when she's in there talking to him, he gets a phone call. They put his dad back in the hospital, and I took my CFO hat on, and I put my friend hat on, my mama hat on, and I started comforting him, and that was the end of it.
So until the moment of the call about the impending declining health of the father, we're in the motive territory. But once the urgency was removed by that phone call, it somehow's off the table?
I still don't think it's motive, because what the cases cited by the state and any case that you look to, for motive, it has to, and the cases that admit these type of evidence in a murder case, is that the person murdered is either the victim, the person murdered is a threat to report the crime, the person murdered has life insurance, or the murderer is bound to benefit financially to get himself or herself out of the financial hole. I mean, none of those typical motive issues are present. What was present is this claim of sympathy, which in West Virginia v. McGinnis, and that really is the closest case that we can find about this, Your Honor. I mean, they reversed a murder conviction for letting extensive financial crime evidence and other information in, and I would read to Your Honor the conclusion from the court in the West Virginia Supreme Court, and it says, the cumulative admission of the evidence under 404B, however, presents us with a likelihood that the jury convicted the defendant because of his character and not because of the evidence surrounding the murder. In these circumstances, these errors cannot be regarded as harmless. And you can't just piecemeal it either. I mean, we spent 10 witnesses over 6 days, 38 transactions.
Was there any 404B evidence that was proffered by the state that was disallowed?
No, Your Honor, not that I can recall. And then, so you have 404B analysis and you have 403, and really the unfair prejudice just by the weight and the extent of that evidence, the sheer volume, 38 transactions, $9.97 million, 10 separate witnesses. In State v. James, I know it's a little different because State v. James involved prior burglary convictions with an enhancement, but the conviction was reversed where 7 burglary convictions were admitted when they only required 2, and they were limiting instructions given, and the court said that was it was not harmless error when you pile on that much, and this was piling on.
Let me ask.
Oh my God, it went on for weeks.
The legal point of whether there's a logical connection or some logical relevancy is using the language our cases have used. I mean, you make a lot of good arguments that it makes no sense. Like this, he would never have done it for this reason. And obviously those arguments are in part, at least, for the jury to iron out, right? I mean, you made them to the jury and that they decide whether this makes sense in terms of a motive. But what I'm asking is, to what extent does the trial judge, when looking at a theory of motive that isn't 100% solid, to what extent does the trial judge analyze the believability, the ultimate usefulness of the theory of motive before admitting the evidence? And just to continue a second, in Lyle, we said that the trial judge has to clearly perceive the connection. Right. In Perry, we of course quoted that, but we also talked about the trial judge using a rigid scrutiny. I mean, really, in Lyle and Perry, though, the question was not the existence of a logical connection, because in Perry, there clearly was one. I mean, in Lyle, there clearly was one, and in Perry, there clearly was not one. At least the majority said so. But in both cases, the real question was unfair prejudice. And I'm just wondering if this idea that the motive theory doesn't work is really a question of unfair prejudice as opposed to a question of logical relevancy.
Well, it's both. You have to do both analysis. Chief Justice Kittredge asked me if it was motive evidence. I don't believe it is motive evidence. It's certainly unfairly prejudicial under 403. And I was, to answer your question, Justice Few, I was about to cite to Lyle, the standard in Lyle, which is a very high standard. And what you had, and I think it should require, and I believe the law makes it require, more than a prosecutor's best theory. I mean, there has to be some evidence to support it. And it has to be like life insurance policy, a windfall, things of that nature.
Or I hate to use this example, but perhaps this looming cloud, storm cloud, so forth, would have given him motive to do harm to someone who was going to blow the whistle on him, instead of,
that's right,
according to you, too many degrees of separation of murdering his wife and child.
Well, that if there was evidence of that, and that's in the case law, yeah, if there were a threat to report, for sure.
There's also another interesting problem that I had with the financial stuff, and that's that Murdaugh, Alec hadn't even pled guilty to those yet.
At 6A, he wasn't
At
convicted.
all.
Yeah.
Well, this happened in 2023. His financial stuff was like a whole year later. So I think it was a bit over. I know, just watching it, it went on for like 2 weeks. It was a tad bit, a little too much, but I don't think that's what they're arguing here. But again, he hadn't even pled guilty for this prior bad acts. It was still just technically an accusation at the time of this trial. But anyway, sorry. I don't know what's going on with my camera, so we're just leaving it, by the way, guys. Over it. Over it.
But none of that existed.
Was there any evidence that Maggie was getting wind of these financial misdeeds? She did have a bounce check or two, right?
Yeah, I believe she perhaps
Was there?
What do you want me to expand on, Mary, in particular? So 404B, what they're arguing here is allowing prior bad acts in from the defendant. Usually these are things that they've committed doing. They don't always have to be crimes, but that's what 404B is that they're arguing here, is about that. And they're saying, like, well, I mean, that judge basically was like, well, that kind of does sound kind of weird, because what was the motivation there for all these financial crimes as being the motive for murder? This is where my problems come in with the prosecution's case, but just from my perspective. But But isn't the time to hide, cover up, stop things from getting worse before you plead guilty? I don't. The financial crimes are federal crimes. They were inescapable first and foremost. Um, but yeah, no. At the time of the trial, the murder trial, he had not pled guilty
Right.
to the federal financial crimes. Now they have those. They have him dead to rights to those. However, as they spent weeks in this murder trial, here's the argument for this is so they're using these financial crimes as the motive that Alec had to commit these murders. Now, they don't have to prove motive in any case. They can try to if they want to, but it's a big part of their story of why Alec did what he did. However, um, he hadn't been found guilty or pleaded guilty at the time, and to dogpile all of these financial things that had not actually been at this time innocent before proven guilty, correct? And so by doing this is making his character, they're focusing on how much of a shitbag he is, which he is. I'm not going to, Alec Murdaugh is a shitbag, okay?
Yeah.
But they are using those financials to use for the strength of their argument as opposed to any other possible motivations. Now, that's what they're kind of arguing here. It was entered in as motive. Absolutely was entered into motive. That's the 404B part. But they're saying, well, what Jim
Right.
is trying to say is by allowing that all in, it was to discredit his character so poorly and it was so much of it that could have factored into the verdict. Now, I'm not saying that's true or not. That this is just what he's arguing on appeals. I don't know exactly what they granted the appeals on for this, but that is what they're saying there. But murdering Maggie and Paul to buy him more time for the financial crimes, because at the time they weren't even crimes yet. It was only known to the law firm. Well, I mean, it could be, but what does that make a whole lot of sense though? It wouldn't have solved any of his problems
That wouldn't
at
have
all.
solved any of his problems.
Not even the life insurance was enough to solve any of these motives I'm sorry, any of these financial crimes. Now, they also talk about how he had a huge drug addiction. There he's spending 20 grand a month. But yet that didn't come with any consequences. Find that very hard to believe.
And
Yes,
did they ever really prove that?
what? I don't know.
That
No,
he
well,
was
he admitted
spending 20,000? I mean, he admitted it, but just because you say it doesn't make it true.
Yeah, yeah. No, I'm just saying this is what Jim is arguing here.
Yeah.
Is over the 404B and it being too much, that the amount that was let in was so damaging to the client that it impacted more of because this trial had nothing to do with financial crimes. The jury was not responsible for deciding any financial crimes. So that's what Jim is arguing here with these points.
Was there any evidence that she was
No,
going
they
to
do.
confront him about
But
money?
It's true.
it's
None
up to the
whatsoever.
state to convince you.
whatsoever.
And Paul, who's described as the detective, was there any evidence that he had any information about his financial misdeeds as opposed to him hoarding pills?
No, Your Honor. It was only his drug use Paul was aware of.
I want to branch off for a moment on page 6,340 of the record. Mr. Waters was cross-examining Mr. Murdaugh. If you read it, it is very, very compelling cross-examination. Of course, Mr. Murdaugh's on the stand, so his credibility is in question. Let's assume that this financial crimes evidence came in reply.
Right.
Because a series of questions that Mr. Waters asked Mr. Murdaugh was, you lie, basically suggesting he lies with ease.
Correct.
Seamlessly lies about everything. Did you lie to your brothers? Did you lie to their wives? Did you lie to Marion Proctor? Did you lie to Bart Proctor? And all these answers were yes. Did you lie to the Brandstetters? Did you lie to Chris Wilson? Did you lie to them about the kennels? Did you lie to Mark Ball? So when his credibility comes into question, then
Right.
could this financial evidence have come in reply? I know that's not what we have here, but doesn't it kind of open the door, or maybe you would have chosen not to put him on the stand had the financial stuff not come in initially?
Well, there are 2 points with that. One, yeah, I don't think we cited case law that we don't waive our right to challenge that by putting him on the stand
I
to
get
address
that.
it.
I get that.
But to answer your question specifically, under 608B, Your Honor, you are not permitted to put in extrinsic evidence of these things. You can ask him about it, but you can't then take 6 days and 10 witnesses. I mean, you ask him the question, and if he answers it, you got it. If he denies it, you're stuck with it. That's what under 608B. You're allowed to cross-examine him, but you're not allowed to introduce extrinsic evidence.
What if the questions had been more expansive? Did you lie to your partners about not stealing $9.7 million? I mean, it becomes, it's a different dynamic, I understand, but what I'm trying to search for is, would this have come in anyway?
Well, I do believe under 608, it's fair ground for cross-examination on his credibility. But then you get to 403 analysis. Excuse me?
You're stuck with his answer, which would have been
Right.
yes.
Yeah. But you don't get to then start putting up 10 witnesses to prove something that he's admitted to.
You get a new trial is coming in, but it's only at least under 608
If he testifies.
if he testifies. And in that event, you get another limiting instruction that says you can only use this to analyze his credibility.
Correct. Thank you.
I've got this question about it.
Oh,
Wait a minute, we're just getting started.
About the weapons? Yeah. We have a question. We want you to argue about the admissibility of the weapons that were seized and introduced that were from Brazil.
yeah. So in the weapons that were introduced in the evidence that were seized from the home, there was no testimony from anybody, even their
Well, beyond that, the experts admitted that he could not identify it as a murder weapon.
well, he said he couldn't include them or exclude them. And so, as we said, these guns, we know nothing more about them today than we did, any other day. Yet they were allowed to put those in the evidence. And we've got State v. McConnell and another case where I think McConnell, where they put 22 caliber bullets in evidence on a shooting case. And the person was shot and killed with .357 Magnum. And that case was reversed. There was another case that we also cited. Lost my place in my notes, but
What was the purpose, as you understand it, for the admission of the weapons that were seized from Brazil?
to prejudice Alex Murdaugh. I mean, that was the purpose. It made nothing more relevant or not relevant. I mean,
Didn't you suggest, though, that the police who investigated this had failed to do a complete job?
Yes, they
and
did.
In particular, that they had failed to properly seek out and find the murder weapons?
absolutely, and that stands
And wouldn't
today.
a simple response to that suggestion be, we looked at every 12 gauge and 300 blackout weapon on the property and here 4 of them?
Now, we thought, I mean, they did a horrible job of investigating this. So we were all like, oh my God, SLED is the worst. And then MSP, Massachusetts State Police, came in and said, hold my beer. And we were like, oh my God, we didn't know it could get worse. SLED did an embarrassingly bad job with this case, which is very interesting because this case is about a very prominent family in the area. And I have questions about that, but it's not good. The investigation just overall was very poor. It was very yikes, much like Massachusetts. Though I would say of the two, Massachusetts was even more egregious.
I should say.
I will say that, but SLED definitely did some things where we're like, yikes.
Here's pictures of 4 of them, but you don't put them into evidence. You can have Greer testify, I tested all these guns. I don't know anything more about them today than I did yesterday. I can't include them or exclude them. That testimony is perfectly appropriate.
But-
After they were put into evidence, were they ever used or referenced again, touched again?
Absolutely. The Attorney General picks it up, holds it up,
Sure
pretends that he's shooting
It was
um,
weird.
somebody. He picks up the 300 blackout and reenacts the crime. Mr.
It
Kinsey
was-
used them.
They can
Yikes.
be used for demonstrative purposes. You just object to them going back into the jury room. Is that what you're saying?
We did object to them going into evidence for sure. And they could have had a demonstrative, demonstrative exhibit to demonstrate to the jury, but that's not what these were. These went into the jury and they did an in-court reenactment with them.
Correct. And they were determined. No, there was no determination if they were the guns or not. That's also the argument here is, hey, we didn't even know. They even said they don't even know if this is the weapon or not. But here they are using it as if it was the weapon, which can be very confusing
Mhm.
of what
'Cause
you're
it's
trying
implied, kind of.
to. Mhm. Right.
Mr. Griffin, I interrupted you a little while ago to segue to the 404B issue. And I think you were either at or near the conclusion of your argument regarding the cell phone experiment.
Right.
And if I cut you off, I didn't mean to, and I want to give you an opportunity if you want to finish any thoughts you had on that issue. It seemed very important to you, and I want to give you that opportunity.
I was done with the cell phone. I was going to go to the blue tarp and then the Dole v. Ohio issues, but I'll rely upon the briefs and Mr. Barber may be able to address it on reply. But I'm happy to stand up here and answer any questions about those issues.
I got a question about the cell.
We have a question.
Help me out here. The evidence was Mr. Murdaugh didn't use his phone from 8:09 to 8:40 something, 8:50, maybe 9 o'clock, right?
Right.
Which was unusual for him, according to the evidence. What does it mean in the testimony of the cell phone extraction?
They all are doing
witness
that.
When a call was in the Verizon records, but not on Mr. Murdaugh's extraction? What does that mean? It's, there's a series, I made a series of notes. This call was not on his extraction. It was on Maggie Murdaugh's extraction, but not his. 905 calls Randolph, not on extraction. Does that mean that the inference is that he physically deleted it on his phone?
I believe so.
And there were probably 10 or 12 or more phone calls that were deleted, if
Right.
that's what the explanation is about not on his extraction.
I believe that is the case, that the information was deleted from his phone for some reason or another.
And this goes to circumstantial evidence of something that he deleted the call. Was there any explanation at trial from your side, not that you were required to give one, as to why those calls weren't on his extraction?
There's no testimony about that at trial.
Okay, all right.
I have thoughts about that, but it's not in the record.
All right.
Justice Hill has a question.
Maggie's phone did not record steps at the
Right.
time, and you make a point about that.
Yeah.
But also the location data got overwritten. Did that override the step data too?
That did not override the step data.
Okay.
And that was maintained in a different place, but the GPS data is pinging constantly and there's only so much room, and SLED did not put that phone in a Faraday bag, which I didn't know what a Faraday bag was before this case, but they give them away at conferences. So it's not,
Mm-hmm.
it's not unique.
Thank you.
Right. We're
No
trying
further
a
questions.
different
Thank you so much, Mr. Griffin. Appreciate it.
plug in. Hopefully that'll work.
Yes,
How
sir,
did
Mr.
What a
Waters.
Faraday bag
Thank you,
was.
Chief Justice, and may it please the court.
I don't know how mostly he does appeals, but yeah, no. SLED didn't do super great with anything. And well, never mind. I'll get to that later. Let's see. We still have another hour, but do we want to go for maybe 20 more minutes and then save the rest for next Monday, or
And we can save the rest for next Monday.
because we got some other things going on tonight.
We
so,
do.
even though it's riveting.
Yeah, I'm like, oh,
I'll start out by saying, and again, I'm not going to, unless this court would like me to go through the extensive facts that were presented here. But fundamentally, our case boiled down to 4 important points. Number 1 was motive, and I know we'll talk about that. And I believe that the motive was very compelling here, and we'll go into that. But the motive pointed to Alex Murdaugh. Number 2 was the means to commit this crime. And what the evidence showed were 2 family weapons were used to commit this crime, both of which could not be accounted for after the crime was over with. Number 3, opportunity. And this was huge. That timeline that was very detailed that frankly the defendant tried to use to be exculpatory actually was very inculpatory and showed that not only was he at the crime scene with the victims just moments before they died, but importantly had been lying about that to anyone who would listen. And that evidence was particularly strong when you look at the fact that when we look at that kind of evidence, we look at patterns. And what was also so important about him being there is that his phone showed no activity, as Justice James mentioned, from about 8:09 to 9:02. And then from 9:02 to 9:04, he had 283 steps, far, far more than he ever had in any comparable period during the review period that we had. So you had that evidence of opportunity showing that he was the one who had the opportunity to commit these crimes. And then finally, you had multiple acts of guilty consciousness of the various things that he told law enforcement and all the rest of it. So that's classic case. It may have been a long case and put it all together, but it boils down to basic good old, how do you determine who did somebody? Motive, means, opportunity, and acts of guilty consciousness. And I think the evidence was very strong with all of that. We started with the cell phone evidence, and I'll go to that as well, since that's what counsel started with.
I mean, we
And
can.
I'm going to start out by saying, first of all, that this is clearly not preserved. I'm going to talk about that very briefly because, as Chief Justice Kittredge pointed out earlier, this was an old school judge. You got old school lawyers, old school prosecutors, and Judge Newman made it very clear at the beginning of this case what he expected with objections, that they be timely and that they be specific. Okay, so this is not a case where preservation is a gotcha moment. This is a case where the judge was very clear about what he expected with that, and the parties that were trying this case are ones who understood that very well. So I think if there's ever a case to look at error preservation issues we've raised throughout this brief, this is that case to do that.
But Mary, my question also has to be, Cousin Eddie was incarcerated. Why didn't they put him on the stand at all? It's very interesting that they chose not to put him on the stand, by the way. Not that there's lots of theories out there to all of this, right? I don't think anyone is necessarily right or wrong, but also then that kind of means that they didn't have as full proof of a case, I feel like, than they put on, for me anyway.
But beyond that, let's look at what happened during the defense case. They called an expert who, Mr. Surgis, who is a former North Carolina deputy who has digital forensic examiner training in Cellbrite and Apple, and he was qualified in cell phone forensics. And while he was on the stand, he used an unidentified iPhone with an unidentified iOS operating system to demonstrate for the jury that just a general motion will cause the raise to wake feature to turn on. And they emphasized that over and over again, that all it took was a gentle motion. Just a gentle motion is all it took. And they did that demonstration on the stand. And so the state, in reply, called a deputy who had extensive training in digital forensic examination, same exact training, who was qualified without objection in the same exact cell phone forensics. And what was more important here was he was here to correct fundamentally what was a misleading statement from the defense examiner, because what he knows, and he knows how these things are programmed, he knows how they work, and the implication that if only a general movement will turn it on, that necessarily a more violent one like slinging it like a frisbee will turn it on, is false, because the phones are designed and programmed, the accelerometer in there are programmed so that while a gentle, normal motion when somebody wants to look at their phone will trigger it, violent motion will not, so that your phone's not constantly coming on when you're jogging or running or doing anything like that. People don't look at their phone like that, okay? And so the phones are designed to do that. So he did the exact same thing that the defense examiner did, except for he did it much better because first of all, he used the exact same model iPhone. He used a similar iOS version that was used, and he manipulated it multiple times in many different categories. And it was there to ultimately disabuse the notion that if it comes on gently, it necessarily is going to come on when you sling it,
Can you
because it
pause
just
Llama?
doesn't. And that is how iPhones work. And
Sure.
So I have an iPhone, maybe the older ones you didn't do this. You can do a setting so that it doesn't wake upon picking up. Like I have mine turned off. Mine, I have to touch it to wake it up. So you can
Oh,
pick
okay.
it up, you can throw it, but until you touch my screen, mine doesn't wake up. Did they ever look at that
I
on hers?
think I want to say, yeah, like that it was a feature that they had kind of a pattern with Maggie's phone. I want to say that.
Okay.
I don't entirely remember, but I imagine that there might have been a time or two. But when we go back to, again, the Karen Reed case and a lot of the phone data, both from Karen and John's phone,
Mhm.
didn't actually match up
Match.
to the inarguable things that were happening, so that's the other area of concern with these. And again, the whole throwing in an office is not the same as driving with the car and throwing it out the window. That's a much better scientific test, but I
Right.
digress on that. But no, I want to
'Cause
say it did show
Because I
that
didn't think
Maggie's
about it
does
until
that.
now, because I just recently
Mhm.
found that
But I
setting.
don't, yeah, I don't remember for sure, but I'm gonna go with yes.
Okay.
Otherwise they would have argued, well, it's never happened before, so why is it relevant?
Right.
That's reason why I think I'm gonna go with yes on that.
Okay.
But I don't remember.
so when he was in cross-examination, and Mr. Griffin did a great job of cross-examining him, and at one point he says, well, I don't know anything about anybody else. Well, maybe that was an inopportune answer, but that's not the end of it, because he went on after that to testify, I have expertise in how cell phones work. I can tell you about the knowledge C databases. I can tell you the ways iPhones, the software is written, what kind of code it's written on, and I can tell you how data is stored on it and the program that's involved in it, the programming that's involved in it. And frankly, his testimony proves the point, because he made sure that the jury understood that just because a gentle raised awake, a general motion will trigger the raised awake, doesn't mean that a violent motion will do that. In fact, it's more likely that it won't, and the phones are designed specifically to do that. That is an expertise that is beyond the knowledge of the average person. And again, this is not one, I think, as we talked about before, where you need to apply the counsel factors and all the rest of it. When you're talking about sort of an experiential type of testimony, the ultimate test is reliability. And he had the same exact qualifications, the same background, and was qualified in the same manner.
But his testimony was sometimes it does, sometimes it doesn't.
That's correct. And that's the
All right, by the way, vote has been decided. We are gonna continue on and finish this out today, so.
We moved our meeting just for y'all.
Yes, we'll do it a different day. Look at, by the way, I love this still shot of Waters.
Yeah,
Like
just
his mic drop. I love it. I love it.
he looks very dapper.
Oh yeah, yeah, absolutely. Listen, Waters is not an idiot, by the way. Unlike, let's go back to Karen Reed, Brennan.
Brennan
I had
was.
questions, but just his post there is just so funny.
reality
I'm gonna need Buffy to screenshot that and use it for future thumbnails, please, and thank you. Because I imagine he's gonna stay for the retrial. Yeah, I would imagine so.
of how it works, because again, these things are programmed to react to different types of inputs, and it's not an absolute guarantee. But the point that was important about that was that just because a gentle motion might turn it on doesn't mean that a violent one would. In fact, it's more likely that it won't, because the phones are programmed to do that, like throwing it like a frisbee.
This is probably not relevant to much, but why this phone being taken from the scene, and why not Paul's? Why not just leave hers there too?
Well, that's very interesting.
Was there any, I know,
Very good question.
is there evidence? I think there's evidence that it was raised to wake at some point and put back down.
Yes.
So that was at 9:02, 9:04, something like that.
Correct. So the evidence, if you look at that timeline, and I could go into it in great detail, but what the evidence showed and what the reasonable inferences from it was, number one, Alec had Maggie's passcode. He did not have Paul's passcode.
You might need to stick closer to the mic.
I apologize. All right. So he did not have Paul's passcode.
Oh, that was the worst thing about they would be, all of them, all over the courtroom the whole time. They're so dramatic. You're muted, babes. Oh, okay.
I said they need to wear microphones on their lapel.
On their second one, yes, please. Yes, please. But that runs issues when they talk to clients and things like that. So I
Take
get
it
it,
off.
but other courts do it.
I know.
But,
I'm
oh
like,
man. Oh, that would be so frustrating. They're so dramatic.
Paul's laying face down, and his phone is laying just on the outside of his rear end, outside of his pocket. And in fact, the defendant told police that he picked up the phone or he tried to turn Paul over and the phone just popped out. Okay. But what's interesting about that is what's so crucial about the time of death and the forensic timeline, as we called it, establishing that time of death, is that Paul was actively in a conversation with his buddy, Rogan Gibson. And that's who the kennel video was for. But he never completed that conversation. And both Paul and Maggie's phone go silent forever and ever, amen, at 8:49, about 30 seconds apart. Well, Rogan continues to try to contact Paul. All right. And so when we look at contact on Paul's phone, there's somebody who actually looked at it and the backlight came on, which is indicative of somebody, the Face ID not recognizing who it was. But as we know, those phones will display like messages coming in. And very interestingly, Alex Murdaugh, in the wake of the brutal murders of his wife and son, yeah, he calls his brother. But then before he starts calling all these other family members, he's blowing up Rogan Gibson's phone. Okay. So the inference is that he saw that he can't get into Paul's phone, but he's concerned about Rogan. The other inference is that he takes Maggie's phone with him because we see steps on her phone. And we also see activity of the orientation changing. And that orientation will only be logged if the backlight is on. And so when he gets back to the house, that's all of a sudden.
I thought earlier the question was asked if the step data also got overwritten. And now he just said that her phone registered steps.
Was it steps or the backlight?
No, he said steps earlier because when the Chief Justice asked, so the GPS data, was it overwritten? Was steps overwritten at the same time? So I just thought that was interesting. And now he just said there's steps registered. So did I. Trying to figure out if I missed something.
I mean, I still haven't figured out, okay, if he did this, why take Maggie's and not both of them? Or like, because they're claiming that, okay, he did this, he took her phone, and then as he's leaving, throw it out. That's kind of bizarre,
Consider
but
he was an
okay.
attorney, I think he would have done something a little smarter.
But then they're
I'm
all
not
like,
an attorney.
well, but
and
then
I
they're
would have
like,
done
well,
something
he was
different.
on a bunch of drugs, blah, blah, blah. Well, okay, so then his entire behavior that night, you're saying he's under the influence, so you can't really hold much against it if he's under the influence. You know, it's very back and forth there. But we're definitely going to rewatch though these phone witnesses that were up there, because the trial channel has already broken them all down. She has a whole playlist of Alex Murdaugh. If you want to go ahead and maybe rewatch it yourself, we're only going to do a few witnesses here and there just for posterity's sake, and it's a 6-week trial that would take forever. But she does have these on there. They're all broken down by each witness too. So as I said, go subscribe to the trial channel. She does amazing stuff. Oh, Amos says the steps were not overwritten. Okay.
So when his phone comes alive from 9:02 to 9:06, there are 283 steps. But at the same time, we're seeing orientation changes and he is calling Maggie's phone. In fact, we can see an orientation change 2 seconds before the call comes in, which is certainly susceptible to the inference that whoever's calling is looking to see that call come in, like somebody who's manufacturing an alibi, like somebody who tells the police in his first interview, look at my phone, I was calling Maggie. He calls her multiple times while he is running around like a chicken with his head cut off and then jumps in the car. And even though he said that Maggie came home because he asked her or she was worried about him, and Marion Proctor testified that Maggie came home to go visit Miss Libby, after all of that, and he's blowing up her phone, he doesn't take the 100 yards down to the kennels to drive by there. So again, not to argue the facts, but all of this was very indicative when you look at this timeline of Alec looking at Paul's phone, leaving it there, taking Maggie's phone, taking it up there, start manufacturing, making sure those calls are coming in. And then as he's leaving out in a haste, he's leaving out of the Moselle, slinging the phone out on the road. And the reason why the backlight, there was an orientation change for that is because the backlight didn't come on. And that was the point of McManigle's testimony.
I'm not asking you specifically, I want to change gears to 404.
Mhm.
I'm not asking you specifically in this case, because I know you believe your motive is very plausible. But in general, how plausible does motive have to be? I mean, could a prosecutor want evidence in and work backwards from there? How does a trial judge analyze that?
Well, I think that the trial judge is fundamentally the gatekeeper and ultimately has to analyze that under the 404 test, which is it relevant? Is it fall under an exception? Is there a logical connection? Is it clear and convincing? And is it, the 403 analysis? I think that.
So not just the evidence you're trying to admit as motive, but the motive itself has to go through a 404 analysis. Is that what you're saying to me?
Well, I'm saying that the evidence that's being presented, every bit of it, yes, has to go through that and be part of that 404 analysis. But I think here, and I'll talk about this, that there's an unbroken chain, and that's why the extent, which it was extensive, but there's a reason why, and it wasn't overkill, it wasn't cumulative. But yes, the trial judge is absolutely the gatekeeper for that. Now, what we did here, and I think this is the best practice, is we wrote a detailed pretrial motion and laid it entirely out, wrote out every bit of it, wrote out the entire theory and put that out for the defense and said, Judge, defense, this is what we're planning on doing. And in opening, I was very careful. I just said, there's going to be things going on in his life. I didn't talk at all about that. And then we did the in-camera hearing and we were very careful. And before I even broached those subjects, I raised that to the trial judge to ensure that the entirety of that was being considered.
Was there any 404B that was disallowed?
There was. So there was 404 of evidence of an offense.
Also, I believe were these the in-camera hearings? If they're the in-camera hearings during the trial itself, when this does come into play, I think those are in the playlist too, if you're interested in those.
Okay.
Pretty sure she included the in-camera as well. But I don't know if he's talking about before the trial or there was quite a few of these during the trial. These in-camera just means in front of the judge and no, none of that stuff, I think. I think that's what's on the list.
Affair that Marion Proctor and Maggie's concern about affair that he excluded as too remote. And then there was a side of the road and narcotics evidence, but ultimately that eventually came into play because of opening the door.
Was there any 404B related to financial crimes that was disallowed?
I think no, but I think that
That's what concerns me. And I want to just gently push back and give you an opportunity to respond. Yes, the judge is a gatekeeper. Unlike the federal counterpart of 404B, our case law has said that our version of 404B is a rule of exclusion, not inclusion.
Right.
And the gate here was just left open. And I couldn't find any example of financial crime evidence that was excluded. And the granular detail and the expansiveness of which everything under the sun was allowed is arguably problematic. Even the nature of the victims, there are many examples here. And I want you to respond, so I'll just share one. I think his name is Tony Satterfield.
Right.
Was testifying. Well, we had to hear about the disabled brother. How is that relate to motive evidence? That appears to be that not only is he a thief with a motive for murder, he's a despicable, low-life character. I mean, the very evil that 404B is designed to prevent, and then ultimately 403 is the final safeguard.
Well, first of all, I'll say that this was never argued nor presented as propensity evidence. And frankly, this court has recognized and other courts have recognized that the less likelihood of propensity when there's a vast difference between the type of 404 crime and the crime it issued. Once once a stealing white collar lawyer, always a wife and son murderer. That's never was the inference and all the rest of it. Satterfield was independently relevant, and we streamlined this inquiry intentionally. And the defense made their general objection to the 404, but never did once we kind of crossed through that door. We presented all of that in camera, never made any specific, like, limit this part, limit that part. We tried to streamline it all. The only reason Satterfield was a witness who testified specifically was because Satterfield was one of the factors in the gathering storm. Satterfield, of course, there had testified that appellant had reached out to him and that he had reached out to appellant in the months leading up to the murders. I think even in June of 2021, asking about the case and about the settlement. And Alec, of course, is lying to him and saying, yeah, I'm still working on the case. I'm still going. But the reality is that he stole almost $3.4 million and had spent it 2 years ago.
But what did one of the Satterfield children's status as mentally disabled have to do with any of that?
Well, I think the point of that was just sort of the background of how Alec had interacted with them and how this was a family that was close to him.
Did the fact that the young man was disabled add to the fact that he stole?
I think what it added to, again, was we had a witness who was testifying for independent purposes. And that was just a background fact of the pressures on Alec, because he had taken this family under his wing, a family who had one individual that he had told, I'm going to help you. I'm going to take care of you. One of whom had special needs. He had spent all of that money. They're asking questions about it.
The sympathy directed toward the victims of the crime is not related to the motive. If he's a thief and that was the motive for doing it, this extraneous information that tugs at your heartstrings is not related to that. And like when I asked you the question earlier, you responded by immediately segueing back to the financial crime itself.
Right.
Not this extraneous stuff of every granular detail of his acts of theft.
Right. And I will just say, in putting that in, that was just, we had a witness testifying. That was part of the background information that witness testified to. And that, again, it was part of his interactions with this family that was part of the pressures, one of a myriad of factors that were all coming to a head in June of 2021.
If you had condensed your theory of motive,
right,
the whole gathering storm thing, down to the essentials and left out all the stuff that the Chief Justice and Justice James were talking about. And in my view, you could have done that in about an hour and a half or 2 hours. You took 12 and a half hours to do it.
Agreed.
And then you're taking that condensed version, you're presenting it to the judge to try to establish a logical connection. This is following up on something Justice Verdon asked, and also asked the same question of Jim Griffin.
Right.
What is the level of inquiry that the trial judge goes into to kind of get to the legitimacy of the theory of motive? Obviously, the jury would be the ultimate decision maker on that. But to what extent should the trial judge question whether it's a valid and legitimate theory of motive?
Well, I think the words of the logical connection are there. And I think that as far as the trial and the clear and convincing nature of the evidence, but I think as long as it is a passable theory of motive and that motive is logically connected to the underlying crime, then ultimately, as you say, it's for the.
In all the cases that I think we've looked at this logical connection question, it's been either easy, yes, there's a logical connection, or easy, no, there's not one.
Right.
Here, it's not easy. It's debatable, right?
Your Honor, I would say, and if you'll permit me, I'll go through why these are all connected and why this is a unique situation, and it demands, it's a complicated situation, and I would submit demands a complicated analysis of the law. It's not the typical case where you have a one-off crime, a few hours. It's not Adams, right, where it's an armed robbery just a couple hours before and they're smoking crack and that sort of thing. This is a long, unbroken chain. And Your Honor, you can't understand the boiling point, which was crucial to the state's motive. And I always say motive is not an element, but it's the only element. And particularly in a case like this, where it's the murder of a wife and son, it is what everyone wants to know. And there's no disconnect between someone having a financial motive for a crime. I mean, it's in the movies, it's in Fargo, it's in the
I hadn't seen Fargo. Get to the point.
All right, yes, sir. All right, but I'm just saying this is in a number of movies. But let's look at why this is all in.
I'm glad you enjoyed Fargo, Waters, because it is very good. But it could have just been like, this is actually like multiple murder cases in this country are because of financial motives. We didn't need to go reference to movies, but hey, he's a Fargo fan, and I like that.
Connected. First of all, it's all interconnected, despite how temporal the temporal time period, because what's relevant to motive is what is in the appellant's mind, okay, and what he knows is potentially going to be and is about to be exposed. It's and that's all of it, and frankly, it eventually was. So what is relevant is not, well, it was just yesterday or it was last week or it was a year ago. What is relevant is what does he know all is about to come out? And that's a decade of him constantly staying one step ahead of the game through one theft as another. And that brings up the second point, that this is all interconnected. It's an unbroken chain, and you can't truly understand, and what is crucial, motive, you can't truly understand the boiling point if you don't understand the slow burn leading up to that. Okay. And the defense put motive in issue is right. Their biggest thing was frankly character evidence of he's father of the year. There's no way he could have done this. So this in the case law says that where motive is a central issue like that, that there is a wider scope. But let's talk about it's interconnected. The jury could not understand the full weight of the pressures if they didn't understand that entire criminal and financial history. You can't understand the need for it without understanding the lifestyle, the bad real estate deals, the maxed out loans. You can't understand the Badger theft of over $1 million if you don't understand that they had, with his bank co-conspirator, had stolen $1 million from the Plier loans, and that had to be accounted for. You can't understand the need for fake forge and why he did that if you don't understand the complications of having to steal that money.
I think all of that is completely accurate.
Mhm.
The disconnect that the defense is getting at and that I'm trying to ask you about occurs when he takes the what the judge called some sort of urgency. He had a nice phrase he used when he was ruling on it. How do you get from that to murdering your wife and son? That's the disconnect that the defense is focusing on. They're not focused on the disconnect between forge and stealing money. That everybody understands that. And my question is, when analyzing that disconnect, what's the point of law? What's the rule of law that we look at, that the trial judge looks at?
Well, again, I think that the trial judge makes that determination of whether there's a logical connection and whether or not the evidence is clear and convincing. And I understand that under South Carolina, there is a gatekeeping function that is there. But I think that as long as that
Let me just throw out a couple of examples and I'm going to leave this alone. Mm-hmm. Obviously, you think there's a logical connection. Is that enough for the trial judge? Or does the trial judge have to decide for him or herself whether there's a logical connection? Or does the trial judge have to look at whether there's a reasonable possibility that the jury might find there's a logical connection?
I would assert that the trial judge should look to whether or not that is a reasonable inference from the evidence. And if it's a reasonable inference, and then it should go to the jury. I mean, that's what we do with all sorts of evidence, is determine whether or not there's a reasonable inference from this evidence. And if so, reasonable inferences are for the jury.
Can I follow up on that?
Yes, sir.
I think Justice Few wrote State versus Perry, and
I wrote 3/5 of it.
Yeah, it helps the Forrest Gump and me understand it.
Mm-hmm.
This 404B evidence.
Okay.
I am also struggling with the logical connection. Your brief is excellent, phenomenally done, but you say in the brief on page 87 that according to Perry, relevant is defined as evidence having a tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable, so forth and so on. You emphasize the word any. And what I fear is if we get on that train and emphasize the word any, that allows speculation to enter the room. Help me out with that, because I would accept, you emphasize in your brief, boat wreck, boat wreck, boat wreck. That's all Alex Murdaugh wanted to talk about when he was on video.
Right.
I get that. So I think there's clear evidence of motive for him perhaps to kill Paul, because this boat wreck case was becoming an anchor around his neck. And then you could stop right there or get into the boat wreck accusation more. But your emphasis of the word any, to piggyback on what Justice Few was saying, I'm struggling with the logical connection that comes from the word any. That means, it seems to me you're just saying whatever we say that makes sense, let's stick with it.
Well, by emphasizing that word, I don't think, and I'm not at all trying to assert that any sort of speculation would be sufficient. What I am saying is, again, the words logical connection. And I think that if it is a reasonable inference, as I just said, I'm not saying that the trial court should just entertain any speculation or any sort of fanciful thing that they come up with. I would, though, encourage y'all, though, to look, not only at the brief, but look at the filing that we did beforehand, and look at the PowerPoints and look at the closing argument. That this is not just a speculative motive. This all ties together, and I had a whole series of how I could go through all of that, I think there's about 10 factors of all things that were all coming to a head, all of that gathering storm that were coming ahead to that day. And that ultimately this, if you're looking at the validity of this, it actually worked. It actually worked, because when all of this happened, Paul, who you just mentioned, had become that liability. Well, Maggie was too. Okay. Her name was on Edisto. Her name was on Moselle. And he was at the end of his rope and unable to move like he needed to move financially, and out of options. He had burned through $792,000 in less than 2 months. And all of these things were coming to a head. But when this happened, everything changed. All of a sudden, he was the center of attention. All of a sudden, the sympathy factor kicked in. All the inquiries stopped, and the boat hearing stopped. The plaintiff in the boat hearing said, this has totally changed the balance of my case. And what did he set about doing? There was testimony that he wasn't overly concerned about Buster security. He wasn't overly concerned about going after the real colors. But you know what he did do? He fixed the glitch. He fixed the glitch so that his lawyer friend would send back or at least send an email saying all the money's here, and put that to bed. So if we're looking for that logical connection, whatever standard is applied, this is not speculative. I understand that it can be hard to accept that. Why would somebody do this? But that's precisely why this motive evidence was so probative and so important. And even though this is a unique case and a unique, maybe lifetime set of facts that will never be seen again, that's all the more reason why this needed to be admitted, and for the jury to fully understand this unique individual from a unique background and a unique set of family circumstances and a unique lifestyle and a unique history that all was about to come unraveled. And that was more important to him than anything. And that when this action took place, not only did 2 of his liabilities go away, but all of those hounds at the gate went away as well. And if it wasn't for a check falling out of a file a few months later, it might have worked. It worked for a couple of months.
I got one more question to go back. What does it mean when something's not on his extraction?
It means that, the inference from that is that the user or someone deleted it.
Thank you.
Ask a question about tool mark.
Sure. Justice Few has a question, sir.
Yeah, I want to flip over to talk about the tool mark testimony by Mr. Greer. There are a lot of cases around the country that have held that this idea of examining shell casings for tool marks is a valid method in trying to determine which guns a cartridge was cycled through. In fact, I'm not aware of any that go to the other direction. So abstractly, it seems to me like it's a valid theory. Maybe not. I'm just setting that aside for purposes of my question. But our cases have required not only that the theory be valid in the abstract, but that the theory be reliably applied. Justice Hill wrote about this in Warner at the Court of Appeals. We decided a case called Galloway recently where we stressed it. And really, I think if you go all the way back to Watson, that's what the court was talking about. As I read this record, there's nothing, I mean, literally zero, about how Paul Greer used the method. He says he used it,
but he didn't say, I found 4 different individual markings. He didn't say, here they are, here's where they were, nothing. And the thing that really troubles me about that is during the cross-examination by Mr. Griffin, I think this was in front of the jury. Mr. Griffin says, isn't your opinion in this case about the shell cartridges being fired from the same 300 blackout, isn't that based upon your presumption that each 300 blackout manufactured in the world makes unique tool marks when it cycles the bullet and ejects it? Now, that's a legit question.
Now, I will say, side note, this is one of the problems with Richard Allen's case. There was an unspent shell found, and the tool marks, they did a series of things, and it came back. They couldn't decide yes or no whether or not it came from his gun. So the topic of tool marks has come up quite often in a lot of things. Like some things are easier to figure out with them, others not so much. But this judge's opinion is, well, why didn't you talk about this whole everybody else does? Why are we not including this stuff that in courts across the country have this, stuff going on? Why didn't that happen? But I'll just say, like, those are some, where they come back kind of inconclusive.
For a tool mark,
They weren't the same every single time, is what I'm saying.
and firearms examiner, in my view of it, there's only one answer, and it only has one word, and the answer is yes. It's like DNA. If DNA is not different in every individual, then the fact that DNA, it would be of no use to anybody. Fingerprints are the same way. If fingerprints weren't unique to every individual, then we wouldn't have fingerprint evidence. We also don't have tool mark analysis of cycled gun cartridges unless each gun makes a unique individual mark, right?
Yes, sir.
So when you don't tell the jury anything about how Greer applied the method, and Greer mistakenly fails to discuss the central theory of the whole method, how have you demonstrated to the judge that the theory was validly and reliably applied in this case to these facts?
Yes, sir. Well, I think as we look at the specifics of the testimony, and I would start with, I think with this issue and frankly, the TARP issue and the cell phone issue, that these are questions that go to weight, not admissibility. And I understand what you're saying.
What Judge Hill said in Warner, or what this court said in Galloway.
Right.
That's not the law.
Right. Well, ultimately, I think that in this particular instance, if you look at the entirety of his testimony, he went through the acceptance generally of this for over 100 years. He went through the SLED procedures. He went through the acceptance and peer review in journals and the quality control procedures, the blind review. So while there may not have been a more specific explanation of that, the general discussion of the applicability and the reliability of the science was clearly in this record. And on top of that, I will also point to this that was in the record that shows that reliability. There's two things. Number one is that the examiner was able to distinguish between the cases around Maggie's body and the cases outside the gunroom door and the cases across the street, and say that those were all cycled from the same weapon, but was able to distinguish those from matching it to the one blackout that was recovered. Okay. And so that distinguishing right there shows an inherent reliability to the science. And on top of that, then another blind examiner came up with that same conclusion. So that ability that was in the record to separate the wheat from the chaff answers the question, even if it wasn't explicitly answered, as Your Honor points out.
Oh,
Thank you for your answer.
sorry.
All right, Mr. Waters, thank you so much. Appreciate your argument,
All
sir.
right. Thank you, Chief Justice and the court.
Mr. Barber, you going to handle the reply?
Sorry, Elba just got home. Scared the crap out of me.
Mr. Chief Justice, may it please the court?
You,
This guy.
I want to ask you, because it's fresh, you don't get 3 minutes uninterrupted. I was listening very carefully to all the arguments. Mr. Waters was trying to defend the admissibility of the expansive nature of the 404B. And I thought he made a very compelling point, because one cannot fully understand, I think he used the word bowling point, without all of these interconnected parts. And so that's the logical connection that gives the judge the discretion to allow the fact finder to consider the evidence. So I'd like you to address that 404B issue, particularly that position argued by the state.
Oh, is this Bauer?
Yes, Your Honor. I thought that the strongest point I really counter that was look at what was actually admitted. We had the victim impact testimony from the financial crimes, which I think the questions made clear have no connection. What did they connect to? Mr. Waters had a theme through his examination of all the witnesses. He asked every one of them, did you know the real Alec? Did you really know him? That was a question that was asked every single acquaintance. Did you really know him? You didn't really know him, did you? The theme there clearly was that you didn't really know. He's really capable of anything. And he's a bad person. You don't know what he's capable of. And that's why that evidence that's why you had the mentally disabled, victim of a financial crime, which has nothing to do with the supposed motive of I need to conceal something because I might get caught. Right. It has to do with, you don't really know me. I'm a really bad person. And because you don't really know me, you don't know what I'm capable of. So please speculate that I'm capable of murdering my wife and my child. That was the purpose of that evidence. We didn't have whatever it was, 12 days of financial crime testimony just to prove the fact that he stole a bunch of money and might possibly have had some fear that he might one day be caught for having stolen that money. And then the speculation is, well, he wanted a distraction. And we can talk about why this would, the logical leap to I'll just murder my family and be the center of attention, and how that's somehow going to get scrutiny off of me, obviously doesn't make a lot of sense. And I think he, more than most people, is in a position to know, given his background, that putting himself at the middle of a high-profile murder investigation is not the best way to distract attention from his own affairs. I believe that's why that's the logical disconnect. And then the real reason that it's admitted is this trial theme that you'll see in every single witness who had a personal acquaintance with him. Every single one asked, did you know the real Alex Murdaugh? And that's why that was admitted.
Thank you, sir.
If I could, I would like to speak a little bit to the cell phone questions that I believe respectfully, maybe the factual predicate behind some of the questions might have been a little off. By way of very quick background, the iPhone has a database that records with a timestamp every time the screen lights up, every time it goes off. Various events will cause the screen to come on and off. An incoming phone call turns it on. It stays on for a period of time. It turns off. Incoming text messages, other kinds of alerts. And then there's this rise to wake feature, which is slight movement of picking up the phone causes it to come on and off. Now there's an entirely separate feature called an orientation change, which is it moves a different way enough to rotate the screen. We've all seen from portrait to landscape. And that only happens if the screen's already lit. The importance of all this is Maggie's phone screen was lit continuously from about 9:02 to almost 9:07 p.m. Right? So it's lit that whole time. It did not just suddenly light up at 9:06 and 12 seconds. At 9:06 and 12 seconds, what happened was the final orientation change, which was a process that took 8 seconds and ended at 9:06 and 20 seconds. Right? And at that time, at that exact time, there was an incoming call from Alex Murdaugh. right? So it's rotating, someone's rotating it while he's calling the phone. Her phone was lit up that whole first, 5-6 minutes because he was called her phone, I believe 3 times, texted 1 time. It stays on for a minute after. That's why it stayed on the whole time. So it could have, if the issue is with the screen lit, it was lit at 9:04, 9:05, 9:06. So if throwing it out of the moving car causes the screen to light up, it could have been thrown out at any of those times. But it goes off before 9:08 and 20 seconds, which is when we now know drove by the point where it was recovered. So the screen is off that whole time. It doesn't come on again until there's another call, 20 minutes later, right? So it's dark the whole time he passes it. So the issue is
This is all directed at my questioning Mr. Griffin about the importance of the expert, of the testimony, the evidence.
What are we doing?
yes, Your Honor, absolutely.
Your answer is that it's important if the murder occurred between 9:02 and 9:07. Why is it important if the murder occurred after 9:08?
Your Honor, it's not when the murder occurred. It's when after the murders, when a phone is thrown to the side of the road.
Right, but the phone wouldn't have been thrown to the side of the road before the murder.
Correct. The point is that at the time that we know for certainty the defendant drove past where the phone was thrown, the screen never came on. There's a long period of time before that when the screen is on continuously.
You make a great point. If all this occurred before 9:07, then my questions to Mr. Griffith were, as you pointed out, factually flawed.
Mm-hmm.
But if it all occurred after 9:08, now you answer the question, because I think the validity of my question is now squarely on the table.
If your question is, could it have been thrown out after 9:08 p.m., then the answer would be that would be inconsistent with the screen not coming on. Yes. The point is the phone had to be thrown out before he drove past that spot. And that fact was not known until near the close of the state's case, right? Because somebody at General Motors was watching the trial, saw when the FBI agent testified on cross that they don't cooperate with murder investigations. Somebody took exception to that, and they produced accurate data. I mean, to pretty much every 3 seconds, not from his vehicle, but from a server General Motors keeps, far away, tracking his every movement, even though it was years earlier. And so all of a sudden we know exactly where he is and know with certainty it's to the second when he drives past that spot, and we know that the phone is dark the whole time. So the question becomes, is it possible to throw the phone out at that moment without the light coming on? And as Mr. Griffin said, we don't know how it got there. Somebody could have stopped the car and gently put it out, but we know he didn't do that. So that's the central question. And the testimony from the defense was, here's the feature, everyone can see it. I'm not qualified to say whether throwing it from a car will cause it to do whatever. If we had an accident reconstruction guy who was qualified to say that. But then the defense rebuttal expert, they bring in a chain of custody expert from the direct who says, well, I threw it around my office. No one saw me do it, but I'm here to offer you what Mr. Waters accurately described as an expert opinion, that if it's a gentle motion, this is what it does. But if it's a violent motion, this is what it does. And this is why it's programmed to do and behave in that fashion. That's clearly expert testimony. It was well beyond his expertise. He was offered as somebody who knows how to use Celebrite to download the extractions that we've been talking about. And as to the preservation, it was immediate objections as soon as this came out. The motion was renewed the first time the jury left the room. The judge ruled, Judge Newman ruled for the reasons he gave in the record, which we assign error to. It was not an untimeliness ruling. So I don't believe that there's merit to the preservation argument there. The judge even said that the objection is preserved for the record.
Is there any dispute that Mr. Murdaugh called 911 20 seconds after OnStar recorded that he arrived at the scene where the bodies were?
No, there's the timestamps that OnStar produced and the 911 timestamps are not in dispute. I would note that the nature it's a rural area, and just because you first got there, it's dark. You don't necessarily immediately see someone the first second OnStar says that you pull up, and you've got to get out and look, and then his phone is connected to the Bluetooth.
Well, what do you say to the state's argument that that's not enough time for him to do what he said he did, which was go check on the bodies, which were 30 feet apart?
In 20 seconds, to look at two bodies that are 30 feet apart, I don't think that's impractical at all. I think I could, if you think about one pace is about 3 feet. If you're alarmed, you could take a pace in less than a second, right? That's not, you don't even have to break a run to do that.
Can you respond to Mr. Waters' comments or argument about the clerk of court?
Absolutely, Your Honor. I think the most important point to point out with that is that there was absolutely no finding by Judge Toll that Juror Z was dishonest. That is not a finding.
She said she was ambivalent.
Your Honor, she said that only as to her response to the question forbidden by 606B about the influence this had on her deliberations in the deliberation room. She said she was ambivalent, whether it was that or pressure from other jurors during deliberations. There was no question of her credibility when she was recounting what Clerk Hill said to her before deliberations began. None. The only evidence presented at that hearing, the only evidence contradicting anything Juror Z said or the alternate said or that was proffered by the egg juror in affidavit, the only evidence whatsoever was the testimony of Clerk of Court Becky Hill. It was not credible at the time, and it turns out that Judge Toll, was good at judging credibility because it has since come out that she perjured herself at that hearing when testifying about a different issue, but about her conduct at the trial. So she was the testimony of a perjurer at that hearing, admitted perjurer, is the only evidence contradicting the statements, the sworn statements from Juror Z, from the alternate juror, from the sworn affidavit of the egg juror. So our position would be that it is would be wholly unsupported by the record to credit that denial from Clerk Hill over all the other evidence in the record. That would, if that finding were made, which the state argues was implicitly made, certainly was explicitly made, that would be an abuse of discretion. However, we argue that that wasn't implicitly made because Judge Toll didn't reach these sort of almost nitpicking, was this said versus that said. She found that in her word exactly was improper. Improper comments were made to the jury. She found that it was a deliberate attempt to influence the jury, that she had a book deal. That was all found. But it didn't matter whether it was this comment or that, because her decision was controlled by an error of law, which was essentially that the defense had the burden to show some sort of but-for causation to the verdict. It didn't matter because it didn't affect the verdict. Whatever was said was improper, but the verdict would have been the same no matter what. That's the written order. And that is the error of law, because the prejudice, which has to be shown, is the prejudice to the fair trial, which is that these things were said to the jurors, right? That's the bias, right? This was said to the juror. That's the bias. We've shown the prejudice when we've shown that it's been said to the juror, because now we don't have an impartial jury. There's no need to show the effect of the bias on the verdict.
He says the comments were fleeting and innocuous. And Judge Toll said limited in subject and not overt as to opinion.
Yes, Your Honor. And maybe to address a question I was asked at the very beginning, is that a question of fact or law? What was said, that's a compound question. What was said is a question of fact. Characterizing it as an application of law to fact is a mixed question. To the extent you have to disaggregate it and say, well, what was said? Again, the only evidence in the record, right, unless you were to accept the found to be not credible testimony of Clerk Hill, who's also perjured herself, the only evidence in the record is that those don't believe the defense was said. Don't be fooled by the defense. That's the evidence in the record. All right, so given that said, to characterize that as neutral as opinion is an abuse of discretion, and it is a misapplication of law to those facts. To find that that wasn't said would also be an abuse of discretion, because it would be a finding wholly unsupported by the record.
I'm just going to remark that it's not fair to you and Mr. Waters that y'all had to talk about every issue, and these other two deadbeats over here only had to talk about half of them. But are you good to talk a little bit about some of the real nuances of the tool mark?
Absolutely.
Okay. You put in
You're muted.
There we go. I double muted because I was eating. He is super sassy.
He is.
Let me
And
tell you what.
I
I know he's
like it.
doing jokes, but I'm just like, sir, my goodness. Okay.
He's trying to lighten the moment.
Yeah. Yeah. All right. Well, we're almost done. Okay.
In the pretrial hearing, or Mr. Griffin did, so the theory of toolmark is set forth in several documents that have been widely circulated and published by the AFT and so forth. But there have been criticisms of those. And one of the most striking ones is this idea that the conclusion, how they reach a conclusion, is circular. And that makes some sense, really. But my question to you is, wouldn't you say that those criticisms go more to the application of the theory than they do to the validity of the theory?
Yes, Your Honor, if I could. It's important to, I think the best way to look at it is to compare it to DNA evidence, because it's so striking, right? Everything in the universe is unique, right? The tool marks are all unique. The question is, do we have a process that can reliably distinguish, the cause of this mark to the exclusion of all others, right? That's the actual question. I did this process, and I can say, with some degree of certainty that, these two tool marks are made by the same weapon and not two different weapons.
To shorten it up, I'm suggesting that you just asked a really good question. Do we have a process to differentiate? And I'm suggesting that these criticisms that have been published, particularly this idea of the circular thing, would answer that question. Yes, we have a process, and it works, it's valid, but it has to be meticulously applied. Is that a fair way of interpreting those criticisms?
It's certainly fair. Where I was trying to go with that is, with DNA evidence, as the court knows from the many DNA cases that it's had recently, these differences are quantified, and you get a very, 1 in 8 billion or whatever chance that these, came from different people that we say it's a match, right? Here, you have this very circular and very subjective. What you have in the end is two marks that look really similar, and somebody eyeballs them and makes a subjective judgment call that these two look really similar. And our basis for that is circular, because we say, well, I look at this part and that part, and it's like, well, how do you know that means they're the same? Well, that's what we've always done. That's what I was trained to do, and it's very circular.
The theory says you have to find whether they match. And the next question is, well, how do you know that? And you say you have to find sufficient alignment. And,
Right.
and nobody ever comes down with a hard rule like you got to find 5 marks on the same cartridge that are identical to the 5 marks on this cartridge. Whereas with DNA, particularly with the ideas like touch DNA, you have
And
the
fingerprint.
experts saying, I was able to identify 8 pairs of chromosomes, and they match to what was at the crime scene, or that to what we found from the defendant, and that gives a 1 in 1 million chance that it is somebody else.
And to do anything like that with tool mark, you would have to quantify the similarity and differences of the tool marks.
And that's what I'm getting at, is all of that goes to the application of the theory, I think, not to the abstract validity of the theory.
Absolutely. And there could be a day that with computers or AI that you can quantify and do something differently. But right now, having somebody eyeball it and say they look pretty similar to me, I think they're the same, that's not a reliable application of the theory. It's totally subjective. It's not quantified in any way, and it's certainly not something that could be subject to any sort of.
I'm trying to get you to concede that the theory is valid. I was really just trying to focus in on the importance of an explanation of how the theory is applied in an individual case. Thank you.
No further questions?
Hearing no other questions, Mr. Barber, thank you so much. And I
Thank you,
speak
Honor.
on behalf of the entire court. I want to commend excellent counsel on both sides.
Agreed.
Thorough, detailed briefs, very helpful to the court and its staff. That is combined with arguments that reflected a commendable command of this lengthy and complex record, together with applicable law. And it has all resulted in excellent arguments today. You've represented your respective positions professionally, and we all on the court commend counsel for both sides. We are adjourned.
Yeah, absolutely.
Yeah.
Yeah. So there's an appeal hearing for you. Well,
I
with the Supreme
love it.
Court, right? Aren't they?
I love
Aren't they
it.
interesting?
It is interesting because everybody has kind of a different view on
Mhm.
things.
I agree, and I think both sides did a great job. They did. I think the state kind of a little bit was like, we're going to revert back to our theory too many times,
Right.
but that is his position, right?
Is
So that
yeah.
is what Waters should be arguing. I'll say usually in the ones I've watched, it's kind of hard to tell where they're leaning.
Mhm.
It wasn't the case in this one.
I was gonna say this one, I'm like,
Oh, they don't sound very happy about
yeah, they
not
don't.
only Becky, but some of the other things that were
Things.
allowed and brought in trial. Now we do know that yes, he was granted a new trial. Maybe when we go for next Monday, we'll discuss a little bit of the appellate's final decision. Probably not going to read the whole thing. We'll see how long it is. But he was granted a new trial from this. I'm going to go with mostly probably because of Becky, first and foremost, because that one, despite all the other arguments they had, that one is really the most
Like you said,
egregious.
that's the big one.
That is the big one. That is the big one. And if you didn't recognize the last guy that talked, I think that's Bauer is his name. He was the one that was always sitting at the end because they had a little L-shaped table for defense. He was the guy that was sitting over there.
Sitting over
the whole
there.
time.
Okay.
So he was part of the team as well. But no, I thought both sides actually did a really good job.
They were impressive.
And it's hard. Again, like you're thinking on your feet. You don't know what they're going to ask. You don't know what they're going to focus on. And also, respectfully, some of these gentlemen are a little older, but it just shows that how sharp they are, including like all of them. All
I
of them. I have nothing bad to say.
I would say I was impressed. I mean,
Yeah,
especially
I mean,
for the guy that helped do the Constitution. I mean, Poot was, he was pretty sharp for his age.
Yeah, yeah. And I thought the judges asked a lot of good questions as well. Anyway, I love watching these kind of things. You don't get to visually see them very often. You can listen into like the Supreme Court ones. They record them even after the fact. It's the United States Supreme Court ones who are overseas viewers, and that it's a similar thing, right? You only get so much time to talk, as you can see. The rest is you answering the judge's questions, so you got to be very careful about what you absolutely need to have in, because you only got so much to do, and you don't know where they're going to go.
You could tell a couple of the questions that they were like, you could just see their eyes get a little bigger because they're like, oh shit, I wasn't expecting that one.
Yeah. Yeah, but the judges did have a lot of interesting questions, not only about the case itself, but as a matter of law. And that's where because appellate courts, it's not we're going to do this whole trial over again to come to our conclusion.
Right.
That's not how these work. They focus on very specific parts and then the law and how it's interpreted, not so much of what happened at trial. So that's why everyone's entitled to an appeal for every case. And especially murder ones, you're gonna appeal for no matter who you are. But so by them going to the Supreme Court, they've already been, working their way up to this. Bye, Dave. Yeah, go ahead if sure. It wasn't for everything discussed today. Yeah, I don't know the specifics, so I mean, I don't really
read it Monday.
Yeah, I'll probably read it over the weekend and see what all they went for and went with. Maybe it wasn't Becky. I'd be surprised if it wasn't.
I was going to say, I don't know how Becky wasn't.
But I mean, she lost her job and everything over it, as she should have, quite frankly. But But no, it was interesting to see all that. Oh, thank you, Mary, for the
Aw.
10 jewels. Appreciate you. Some happy poop. It's my favorite jewels that you can give us because I love that. Um, but yeah, so I thought that this would be a really Becky was the only reason. That's
Oh,
not surprising then. Okay.
they
Okay.
just, it was so egregious. Why deal with the rest, maybe?
Could be. Could be. I would if I was the state with this retrial, the things the judge had questions about evidence-wise, I would really hone those in because they were not wrong.
Oh,
Because
no.
those were things that I had problem as a casual person watching the trial, right? Because the people in the jury are gonna be casual people. If I was on the state, I would be like, "Okay, so we
Yeah.
definitely need to focus our
They
energy here," 'cause
should
they were
take notes and use it to improve what you can do better.
well, because I mean, we're talking about, the highest judges in South Carolina here. And if they're doing that, then they're considering it when they're listening. All right.
Mhm.
Um, that you would want to concentrate to avoid additional appeals on a new
Right.
trial if he's found guilty. So that's interesting. It's your favorite too. I know, right? Um, yeah, and what Becky did was enough, honestly. That's enough to
Yeah, that
grant a new
it was
one.
enough
And
for me. I mean, I knew there would
and
be one because of her.
yeah, yeah. As soon as I heard about Becky, I was like, "Yep, you're good.
Yep.
You're good." Yeah, they're definitely gonna have to sharpen their case in chief with this.
Yeah.
The defense is going to go hard
Oh, yeah.
with the infotainment because they did not have time in the last trial to do that. As they said, General Motors called up and was like, "Yo, we actually
Get
have
that.
this. Here you go." And they did not have time to look at it.
Yeah.
So of course we're gonna hear more infotainment testimony, which is now our dreaded
I just
testimony. We're
I
gonna
kinda
just
like the infotainment because I'll think about it sometimes in my car when I'm doing something. I'm
Mhm.
like, "Oh, if something happens to me, they're gonna look that up."
Yeah. And I don't doubt for 1 second that Waters isn't going to go through and perhaps even rethink and go about things in a different way that he wants to bring up based on what the judges
Asked.
uh, asked question-wise, even though it wasn't written in the appeal. Um, because again, those were some not great points
Yeah.
for the state
They don't want
that
a
I had
second
problems with.
appeal.
No, no, no. They don't want a second appeal either way, right? First and foremost, though, everyone deserves a fair trial. It doesn't matter if he got a guilty verdict or if you think he's guilty or not guilty. Same for me. It's that he did not get a fair trial
He didn't.
because of Becky. Or, well, we don't know that Becky's influence on the end really mattered, but it doesn't matter,
It
right?
doesn't
Because
matter.
that little amount of interference into a court case can upend everything. Now, if
Yeah.
Becky wouldn't have happened, I don't know if they would get an appeal either based on the other conditions, but hmm, yeah, right. As soon as we all heard that, we were like, girl,
Yeah. Yeah, that was
girl,
like,
what
yeah, Becky.
what? But the judges implied, listen, a lot of that was shaky. A
Yeah.
lot of the state's case was in fact shaky to some degree. Um, Yeah, if they're smart, it won't be as much because it
Mm-mm.
was very problematic. Now he's pled guilty to
I
them, but
should
at
say,
the
but
time
now
he
he's
hadn't.
pled guilty, so
Now will he take the stand again? No. I'm gonna tell no way
I
he's
was gonna
taking that
say,
stand
I
again.
don't think he would.
I don't think so either. Um, which I mean, maybe we didn't think he was gonna take the stand in the first
And
place,
how are they gonna find a
but
jury that hasn't heard of this case?
they're going to have to move either the trial or bring in a jury from a different part of the
Yeah,
state,
they're
probably.
it's the
Um,
only thing they can do
Yeah,
because
well, it's not a very big county at
no, but I
all.
mean,
It's
everybody in the state knows about this case.
That's true. That's true, but the local consensus at this point, even with Becky, everything, I don't know for sure what's been filed in court yet, but I'm sure change of venue, it's
That's
first on the list.
Mhm.
And both might be okay with that. So they did find a new jury for Karen Reed within a year, so that's true, late and grade. However, that is a much higher population density area than this small ass county in South Carolina. We're talking about
And
a huge different demographic.
and the Murdaugh family was well known in the state for many, many years in the legal. They're much more known than Karen Reed. Karen
And
Reed was basically a nobody.
particularly in the area.
Uh-huh.
So I wouldn't be surprised if, I don't know, again, I don't know if anything's been granted, probably not yet. But
Mary, if you just disappear and we don't see you on our streams during his trial, we're going to be like, oh, Mary is so on that trial.
And don't talk to us.
And don't talk to us. Do not
Until
log
after.
in. Don't do anything, but we would like to invite you on afterwards.
Yeah, for sure. I think it's the right call. Whether or not the outcome will be different, we'll wait and see with what the state's
Yeah.
going to do with a retrial. I think everybody should go in clean slate to everything because it's about what the state is going to present in this trial,
Right.
not the last one.
We
The last
got to
one,
go in
it didn't happen.
brand newbies.
Brand newbies, and hear it out on both sides and judge it based on that. Remember Karen Reed, the first one, mistrial because the jury wasn't sure. Second one, not guilty. So it can vary. And that's also why I think the state is going to hone in on some of the things the judges brought up. Because, yeah. Now, not very many people are in the camp of not guilty on this case.
Right.
But all you do need is that one, which, one person can do a lot. So,
Well, look at what Becky did, and she was just one person.
yes, we get exclusive interview post trial.
But I think when they ask you if you know about this case and they hear everything, you're not going to get selected.
Oh, their jury selection is going to take forever.
Oh, yeah.
It's going to take so long. I don't think that it's going to necessarily need to be 6 weeks again. But we'll see. We'll see. I believe they're all on the new trial too. So
Wow. I'm
right, there
excited.
is a difference between thinking he isn't guilty and the government didn't prove his guilt.
Right.
Absolutely. The burden is on the state.
Right.
And it's the highest burden in all of the land. So
I mean,
we'll see what
before
they
I
do.
sentence somebody for life, I need to be sold.
Yeah, absolutely. Absolutely. But they're all impeccable lawyers. It is
Yeah.
going to be it is not going to be the same as the last trial. I can assure you that because again, that's the most recent one that I know a lot of people
Oh,
who
it was
haven't watched trials
totally
before.
different.
That was like their first one. We are going to see very similar things with the lawyers in this one as well going at it. Except honestly, I don't think Waters is equivalent to Brennan. But anyway, I'm very interested to see where things go, what they're going to focus on this time, how they're going to, connect it all together. Because like I said, for me, there were just some parts that just didn't quite get me there. So we'll see. As I said, I know
See
he's a
if
piece of
they're
shit,
able
but
to convince you
we'll see.
or if you're going to stay the same.
We'll see. The judge set the trial for April 5th, and she already warned them she doesn't go for postponements. They've already had plenty of time because they already did the trial. So I think April 5th is solid.
Yeah.
Because besides getting some new experts that might need time, that's when they do it right now. And I would say April 5th is very reasonable for a retrial in this case with not really any new evidence. So hopefully
As a gun
you are
owner,
all doing it.
but anybody who knows anything about gun, even if you unloaded that damn gun yourself, you don't point it at anybody.
Yeah, it was. They were.
I'm
they were
sorry.
messed up,
That's
man.
one of the,
Mhm.
yeah.
But we'll see. So next Monday, we'll be back with more
We'll be
Murdaugh.
back.
We're going to watch the first hearing of his new trial,
Okay.
as well as we'll read over the appellate thing, and I'll see if there's anything. We're not going to probably read
Anything
the whole thing.
juicy.
Maybe some interesting parts that we might want to draw attention to. And then we'll also end up going over, because, I'm sorry, his retrial, the next hearing is August, what did I say was 14th? Whatever that Friday
14th,
is.
something like that.
He'll have one in the morning. So we'll see how that goes. And then, of course, we're also going to do his Alex Murdaugh's civil suit against Becky as well. because that's very interesting, and we don't see a lot of lawsuits that are like that. And so I think it's really worth covering and talking
Was
about.
she
So
charged criminally for perjury or anything?
I feel like there was
I'm thinking
something,
I
but I
saw
don't remember.
something, but I don't
I don't.
remember. I'm like,
Yeah, I don't
"That-"
want to say one way or another
I
because
will look
I don't
before
know.
Murdaugh Monday.
I know she lost her job
She lost her
because
job.
of it. She committed perjury, but
So I'm
did
saying she
she?
committed perjury, so
I-
that should be,
And there was like that whole weird thing with their son. It'll be in the civil suit. Don't worry.
yeah.
We'll talk about it
So
more there. But I guess that's
that's
all we really
nuts.
have for today. It's like
Yes,
a throwback.
it's a
Hearing these
throwback.
guys again just like brings me back to 3 years ago when I finally found my little online trial community, and here we are now
Here we
covering it
are.
on our side on the screen. It's so weird.
Oh,
Oh
she
yes.
pled guilty. Okay, so I did
Okay.
remember that. Okay, I didn't know. Sometimes all of the cases kind of start blending.
Yeah, for sure. Especially with this one when it's been,
Yeah,
several years of many different events. But so state criminal charges of misconduct, perjury, and obstruction of justice in December 2012. Yeah, they were definitely giving a new trial. Yikes.
yeah.
Yikes. That was enough right there. All right. Well, let's see. We have a little bit of a free break before our members appreciation only
Yes.
stream tonight,
Go eat
7
some
p.m. Eastern.
food.
Yep. We'll be back for members at 7 p.m. Eastern
Okay.
to do giveaways, all that fun stuff. And then you have something tonight.
Yes, I am back with the Dearest Mother's Darkest Secrets tonight, and we're covering China Arnold,
Oh,
and it's a
mm,
horrific one. It's a rough one.
yeah. Yeah. And then, excuse me.
She admitted to taking 12,000 in improper
Mm,
bonuses.
yeah. Becky's not great. As I said, Murdaugh's not the only corrupt person in that area
Oh no,
or
that
in this state. All right.
I've
Ask
always heard
yourselves.
the back countries
Ask
that way.
yourselves.
It's
Wait
the
a
good old
second.
boy system
There,
still.
there are some things that are quite interesting, much like Massachusetts, and what's been going on over there. But then tomorrow for Couch Court with Llama, I think we're going to be watching Lindsay Clancy's opening statements from today. I'm not covering the whole trial because it's very long, and unfortunately, I can't. One, my schedule doesn't allow it. But two, it's too heavy for me to do nonstop. But
That's
I heard the opening statements were really, really important today, and the case is very important.
it
And
is,
I
but
just know
it's
my limits.
yeah.
So I want to encourage people to watch it, but I heard that the opening remarks are going to make me very mad. So we're going to do that, and then we'll be getting to some Karen Reed, some Warren Lowe, some Bam, all of that. We got a lot going on for you guys.
Got a lot
So
going on. Well, cool. Well,
anyway,
hopefully everyone that's a member, hopefully we'll see you on the member appreciation stream. And if not, come to the Dearest Mother stream tonight.
that's right. And if you're on Replay Crew, make sure you've
Yes.
liked, subscribe, hit the notification bell, and the hype button
Hype
on this
it.
video. And we appreciate all of your guys' time being here today and listen.
Yes.
Listen, it's okay if we agree agree to disagree, or I meant just disagree
It's
about
okay.
facts of the case. Like
You don't
that's
have to agree to disagree. You can just disagree respectfully, people.
yeah, yeah. But I that's what I find so interesting is the different perspectives with every trial. Like we've
Oh,
only watched one trial where everybody was 100% fuck this guy. And that was the New Hampshire versus what was that douchebag's name? Dustin, what was his name? The one that shot the mother of his children.
oh,
Durant.
Durant,
Durant, something like
something
that.
like yes.
That was the only one where we did a poll, 100% everybody. Like that guy was ridiculous. But that is also something that makes our justice system unique is different
It does.
perspectives, and what works for one person doesn't work for
Mhm.
another. And that's the beauty of law. I mean, sometimes it's not great, but it is what we have. Duran,
With
yes, thank you.
Duran.
Dustin
Okay.
Duran. Oh, that guy. I still hate that guy. Anyway, all right, friends. Well, we will see you all tomorrow or
Yes.
tonight,
That's
whichever.
right. Stay safe,
I
guys.
Until next time, go forth and be amazing. All right. Bye, friends.
Bye, guys.